I can't believe this has happened. People are greedy and stupid, and stuff like this happens, I guess, all the time, unfortunately.
Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. Hello everyone, and welcome back to another live stream with me, Grizzly. This is Grizzly True Crime, and today we are waiting now for closing arguments. So I just wanted to see, because you see now there's a little bit of waiting time as they bring the jury in. So I just wanted to wait because, as we know, if you've been here a few times watching trials with me, when it's closing argument time, there's a lot to still prepare. But I've decided to go live now. Jessy's got her cross out fully today, okay? So if you've never followed this case, this is the defendant who's on trial for the murder of her friend, the victim, Lynn Hernan, pictured above me here. Lynn was 62 when she died on October 3rd of 2018. And Jessy's facing first-degree murder charges as well as 2 counts of felony theft. Now they are inviting the jury to come in, so let's put the sound on. Okay. And we're getting ready for closing arguments. They are first going to be giving instructions and then going into closing arguments. And just from the little bit I heard now, before the jury came in, they're looking at 90 minutes per side. 90 minutes, a break, and then another 90 minutes for the other side, for the defense, right? Stefan says, Pablo is still rehearsing. Yes. Pablo is still rehearsing. He's like, I need a break in between. So I've also put a poll up. Let's see what you guys say.
Everyone, please be seated. Good
Most
morning,
of you
ladies
say
and
1 to
gentlemen
4
of the jury.
hours. Okay, can you hear properly, guys?
I want to remind you that the instructions that I will be reading this morning, as you can see, I have a packet. I read them in 2 portions. The initial portion, which is the bulk of them. Then we'll start with the state doing their closing arguments. We'll take a mid-morning break. I think it'll time out perfectly for that. And then we'll come back for the defense to do their closings. After both parties have done closing, the state also gets a short rebuttal. There's a few more instructions that I give you, and then after that, the case is given to you. But you will get the entire packet with you back in the jury room. And then, of course, there's the issue of the alternates. I wait until right after I hand the bailiff the instructions to give to you, and I'll notify you who those 3 will be. You 3 will still be here, kept in a separate jury room with the same instruction. I won't read it, but you know not to discuss the case, even with the 2 others who are there, because you're technically not part of the deliberations, but I will keep you just in case there's a need for one of those who are deliberating if something were to happen, whether you all today, tomorrow, whatever it is, however long you take to deliberate. I just want to make sure we have that kind of cushion, and that's why we have alternates. So with that, I will start with my instructions, and once I'm done, I'll have you stand and stretch for a little bit too. All right, members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinion you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count of the information in this case charges that Jessy Kurczewski, on or about Wednesday, October 3, 2018, at N16 West W26543 Meadowgrass Circle in the city of Pewaukee, Waukesha County, Wisconsin, did cause the death of Lynn Hernan with intent to kill that person, contrary to Section 940.01 sub 1 sub A of the Wisconsin statutes. First-degree intentional homicide, as defined in Section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. 1. The defendant caused the death of Lynn Hernan. Cause means that the defendant's act was a substantial factor in producing the death. 2. The defendant acted with the intent to kill Lynn Hernan. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that her conduct was practically certain to cause the death of another human being. When may intent exist? While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. Deciding about intent. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent and motive. Intent should not be confused with motive. While proof of intent is necessary for a conviction, or to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Lynn Hernan with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count of the information in this case charges that Jessy Kurczewski, between approximately January 1 of 2016 and October 3 of 2018, at N16 W26543 Meadowgrass Circle Number A in the city of Pewaukee, Waukesha County, Wisconsin, did intentionally transfer movable property of Lynn Hernan having a value that exceeds $100,000 without consent and with intent to permanently deprive the owner of possession of the property, contrary to Section 943.20 sub 1 sub A of the Wisconsin statutes. Theft as defined in Section 943.20 sub 1 sub A of the Criminal Code of Wisconsin is committed by one who intentionally transfers movable property of another without consent and with intent to deprive the owner permanently of possession of the property. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. 1. The defendant intentionally transferred movable property of another between January 1, 2016 and October 3 of 2018. The term intentionally means that the defendant must have had the mental purpose to transfer property. Movable property means property whose physical location can be changed. 2. The owner of the property did not consent to the transfer. 3. The defendant knew that the owner did not consent. 4. The defendant intended to deprive the owner permanently of possession of the property. Deciding about knowledge and intent. You cannot look into a person's mind to find knowledge and intent. Knowledge and intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge and intent. If you are satisfied beyond a reasonable doubt that all 4 elements of theft have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The 3rd count of the information in this case charges that Jessy Kurczewski, between approximately October 4 of 2018 and July 9 of 2019, at N16W26543 Meadowgrass Circle No. A, in the city of Pewaukee, Waukesha County, Wisconsin, did intentionally transfer movable property of the estate of Lynn Hernan, to wit, money, having a value greater than $10,000, but does not exceed $100,000, without consent and with intent to permanently deprive the owner of possession of the property, contrary to Section 943.20 sub 1 sub A and 3C of the Wisconsin statutes. Theft as defined in Section 943.20 sub 1 sub A of the Criminal Code of Wisconsin is committed by one who intentionally transfers movable property of another without consent and with intent to deprive the owner permanently of possession of the property. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. 1. The defendant intentionally transferred movable property of another between October 4 of 2018 and July 9 of 2019. The term intentionally means that the defendant must have had the mental purpose to transfer property. Movable property means property whose physical location can be changed. 2. The owner of the property did not consent to the transfer. 3. The defendant knew that the owner did not consent. 4. The defendant intended to deprive the owner permanently of the possession of the property. Deciding about knowledge and intent. You cannot look into a person's mind to find knowledge and intent. Knowledge and intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge and intent. If you are satisfied beyond a reasonable doubt that all 4 elements of theft have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. An information is nothing more than a written formal accusation against the defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. the law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Evidence is first the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. The district attorney and the attorneys for the defendant have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. In this case, the district attorney and the defendant's attorneys have stipulated to the following facts. Lynn Hernan received Quest food share benefits from the state of Wisconsin from 2015 through the date of her death. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility. That is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial. The witness's conduct, appearance, and demeanor on the witness stand. The clearness or lack of clearness of the witness's recollections. The opportunity the witness had for observing and for knowing the matters the witness testified about. The reasonableness of the witness's testimony. The apparent intelligence of the witness. Bias or prejudice, if any, has been shown. Possible motives for falsifying testimony. And all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. Evidence has been received that some of the witnesses in this trial have been convicted of crimes. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. Evidence has been presented regarding other conduct of the defendant for which the defendant is not on trial. Specifically, evidence has been presented that in 2010, the defendant attempted to obtain a car title loan at a payday lending store by using someone else's personal identifying information and attempted to open a savings account in the name of another person. If you find that this conduct did occur, you should consider it only on the issues of motive, intent, and absence of mistake or accident. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the theft offenses charged in this case. The evidence was received on the issues of motive, that is, whether the defendant had a reason to desire the result of the theft offenses charged, intent, that is, whether the defendant acted with the state of mind that is required for the theft offenses charged, absence of mistake or accident, that is, whether the defendant acted with the state of mind required for the theft offenses charged. You may consider this evidence only for the purposes I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offenses charged. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things. Whether the statement was actually made by the defendant, only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial, whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statements deserve. A defendant in a criminal case has the absolute constitutional right not to testify. Ms. Kurczewski's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. The jury has heard testimony and seen evidence that at times during the investigation the defendant was in custody. The defendant's custodial status must not be considered by you in any way and must not influence your verdict in any manner. The jury also heard a statement that the defendant and Ms. Hernan are felons. This is not relevant and must not be considered by you in any way and must not influence your verdict in any manner. It must not be used for any other purpose, and in particular, you should bear in mind that a criminal conviction at some previous time is not proof of guilt on the offenses now charged. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating an opinion about the evidence. You, jurors, are the judges of the credibility of the witnesses and of the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. Remarks of the attorneys are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Consider carefully the closing arguments of the attorneys. But their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdicts according to the evidence under the instructions given you by the court. Now, before we have the state come up to present their closing arguments, just want to give you a chance to stand for a minute and stretch.
Stretchy boy. Pablo's getting ready. Pablo's taking a stretch very seriously. Thank you for being here. I don't want to interrupt, of course. So we're just sitting here listening to all of this with all the fluff. This is the fluff now. Such perfect timing. We were all caught up by the time it's closing arguments, right? Love it, love it. Jessy looks wrecked today.
Yeah, we can't do that. We'll have to.
Very tired, nervous, staring at the jury. I hope you can hear me. I'm trying not to shout. I boosted the sound.
All right, thank you, everyone. Please be seated. Madam Reporter, you've got a good view of everyone you need to.
Go.
All right. Attorney Nickolie, go ahead when you're ready.
Thanks, Judge. Sorry, we're a little crooked.
Ooh, we're going to see the timeline that they've been
State's
drawing.
table.
Here we go.
Good morning, ladies and gentlemen. And on behalf of the state's team, attorneys Crawford and Sitzberger and myself, as well as detectives Hoppy and Plennis and Ms. DeVolcanier, thank you so much for paying such close attention during this trial. I have to say that it stuck out in my head when I would look over at how carefully you were all listening, and we really do appreciate that. This is my opportunity to argue the case. The evidence is in, and soon you'll be asked to deliberate whether we've met our burden in this case on all three counts. All three counts follow this theme of murder, greed, and lies that my co-counsel introduced during opening statements. And that's how we'll discuss it here this morning, starting with count 1, the first-degree intentional homicide of Lynn Hernan, and moving into the greed. Count 2 being the theft while Ms. Hernan was alive, and count 3 being the theft from Ms. Hernan's estate. When we talk about count 1, the judge just read you the elements. Ladies and gentlemen, we submit to you that in this case, Ms. Kurczewski caused Lynn Hernan's death with the intent to kill her. You heard moments ago that it's not necessary that every fact be proven directly by a witness or an exhibit, and that in fact circumstantial evidence can be just as powerful. Whether it's direct or circumstantial evidence, the only thing that matters is whether it satisfies you beyond a reasonable doubt. The circumstances in this case are significant. The cause of death in this matter, as determined by Dr. Bedritsky, is poisoning. Tetrahydrozoline is a poison. Dr. Bedritsky talked to you about her job. It is her job for Waukesha County to make determinations on cause and manner of death. She told you that it took her almost a year to do that in this case. She was the only expert who actually saw Ms. Hernan. She performed the autopsy. She testified that she viewed Ms. Hernan's tissues microscopically. She sent numerous toxicological samples to NMS labs. She reviewed thousands of pages of medical records. She conducted research and consulted with other experts and considered the facts at the death scene. And ultimately, she told you, without hesitation, that the poisoning that occurred in this case was at the hand of another. That's what homicide means. Death at the hand of another. Dr. Bedritsky was not here to tell you who did that. She was not concerned with that at all when making these determinations. That's not her job. But she did testify that she considers this case to be unique in a couple different ways. Definitely, the toxicology was atypical. That scene was atypical. And she told you it was atypical both because of things that were there and things that weren't there. like tetrahydrozoline bottles. Dr. Bedritsky told you that it was significant to her.
Guys, I'm quickly going to make one switch for you, okay? I found a stream that doesn't have those logos on so that I can actually make it nice and big and we can read everything that they say, okay? So just give me 1 second. Don't worry, we'll catch up in a moment. Stand by. It'll be worth it. Okay? Here we go. We're going to boost that as well. Off we go. And here we go. Okay. So now we can see all the presentations they show.
She was not concerned with that at all when making these determinations. That's not her job. But she did testify that she considers this case to be unique in a couple different ways. Definitely, the toxicology was atypical. That scene was atypical. And she told you it was atypical both because of things that were there and things that weren't there. Like tetrahydrozoline bottles. Dr. Bedritsky told you that it was significant to her that of all the medication, pills, and bottles, and powders at the scene, that Ms. Hernan's toxicology did not indicate elevated levels of those prescriptions. Certainly not fatal levels. There was only one poison in Ms. Hernan's toxicology, and it was eye drops, and they weren't on the scene. I submit to you, ladies and gentlemen, that the misleading scene that caused investigators from day one to believe this was a pill overdose was very intentional. It was intentional by the only person who was there, other than Ms. Hernan. It was an intentional way to mislead. This theme of Ms. Kurczewski's intent being to mislead will carry us through the rest of the discussion this morning. And the motive? To get out of trouble, right? Because what was presented by Ms. Kurczewski to the first responders at the scene was not at all what the actual cause of death was. Ms. Kurczewski talked about how ill Ms. Hernan had been, how she liked to use her pills. There's no suicide note. Dr. Bedritsky talked to you. Ms. Hernan was not on the verge of death. This chart looks at the substances we've talked about so many times in this case. Again, only one of them is a poison. And I submit to you that the fact that the poison is in the toxicology is circumstantial evidence of the person's intent who gave it to her. The other substances underneath the tetrahydrozoline are not anywhere near fatal levels. Dr. Bedritsky told you that even together, those other substances would not have caused the death because it was the tetrahydrozoline that was so significant that that level was fatal. You were asked to make a lot of assumptions about perhaps Ms. Hernan's character, I guess, in the fact that the baclofen and cyclobenzaprine were even there, right? Because she had been told to stop taking those. They shouldn't have been there. They shouldn't have been there. You kept being told. They shouldn't have been there. The tetrahydrozoline shouldn't have been there at all, because if she was using it as eye drops, it would have been under 1. The level would have been under 1.0. The reason Ms. Hernan wasn't taking baclofen and cyclobenzaprine is because she herself reported having side effects she didn't like. And they were not life-threatening side effects. They were rashes. They were salt in her mouth. They were weight gain. When you think about all of the counts in this case, you're going to have to think about who Ms. Hernan was. And I want you to think about the different sources of information that you've received during this trial about Ms. Hernan. And consider the sources of that information. You heard in this case from 3 of Ms. Hernan's closest friends. People that she loved. Anthony Poza told you he would go over there and she'd make him lunch during college and they'd talk about movies, black and white movies. They'd talk about her dad, who was in the military. Corrine Poza showed you birthday cards that she still had from Ms. Hernan. She was a very thoughtful person. She liked to cook. You heard that she would bring food to parties. Corrine Poza told you that they had an affinity for shoes together, and she laughed a little when she looked at that note on one of the birthday cards. Corrine Poza told you that she had gone thrift shopping and rummaging with Ms. Hernan because she loved to get a deal. Ms. Hernan was making plans with these people. Jim Kelleher told you they were making plans because he still had a birthday gift for her after she got out of the hospital. Anthony Poza and Keith Lang saw Ms. Hernan after they had had lunch and she made plans to see Anthony soon. Ms. Hernan was always thoughtful about her appearance, and that's significant. She gave gifts that were meaningful, not necessarily expensive. She was overall, as we've seen in the patterns presented, frugal. She had a very high credit score. She paid cards down. She didn't spend a ton of money. She certainly was not someone who used technology very well. In fact, Ms. Poza told you that when she'd have photos of Anthony, Ms. Hernan would want her to physically send those to get printed so she could pick them up. She could not even manipulate the photo application on a smartphone, let alone some of the other things that she's been alleged to have been involved with in this case. She loved her pets, and you heard even from the insurance agent, she was a thoughtful person, making Christmas gifts of food, low-cost items. That is in great juxtaposition with how Ms. Hernan's been portrayed in this trial. You heard over and over that she was angry. She was so angry, she was giving up. She wanted to get rid of all of her money. For some unknown reason, she wanted to have no more liquidity at the time of her death. She was suicidal. How many times did you hear these things about Ms. Hernan?
Too many. Too many times.
And the suggestion that she was apparently scamming the government because she got food share. Hiding assets from the government to accept government assistance. I want you to think about the sources of these kind of attributes for Ms. Hernan. Because ultimately, ladies and gentlemen, you're going to have to make credibility determinations in this case. And you have to consider what intent the source of information had. Was it to mislead you? Was it to shift your focus? What's the motive behind those kind of statements? You need to consider that when you're deciding about intent. Because at the core of this case really is the defendant's intent and the lack of consent for those theft counts. And those are all questions that Ms. Hernan can't answer because she was murdered. That's why these questions have to be answered with circumstantial evidence. And that includes motive, which is different from intent. But it's someone's reason for doing something. I submit to you, ladies and gentlemen, that in this case, Ms. Kurczewski's intent is clear. It was to kill. The intent behind her lies is to mislead. And the motive is her own personal benefit, whether it be getting out of trouble or money. Count 2 is the theft while Ms. Hernan was alive. Again, these two things Ms. Hernan can't tell you about, so we rely on the circumstances. One significant one is the difference in the patterns that you saw between Ms. Hernan and Ms. Kurczewski in this case. There was testimony about this and information gleaned from all of the financial records about these. Ms. Hernan was paying cards down. She had a great credit score. She wasn't using a ton of ATMs. She wasn't lavishly spending, right? You heard that she bought herself a vehicle and some jewelry, but really other than that, she's not going on vacations. She's not buying computers and iPads and things, televisions, and she's spending her money in Waukesha County in person, not online. You saw the patterns of Ms. Kurczewski in this case. The credit cards are close to their max. There's a lot of ATM and cash advances. The spending is happening at places where Ms. Kurczewski can get cash out and gamble. Whether it be a casino or a bar, there's been testimony in this case that Ms. Kurczewski spent significant sums of money on slot machines in the geographic area where she lived, and additionally using a lot of online activity. You were shown this credit score comparison, and you'll see that when Ms. Hernan's score plummets is the same time that all those credit card accounts are maxing out, becoming due. No payments are being made on loans. Her score plummets in the last 3 or 4 months before her death. And ladies and gentlemen, the financial aspect of this case and the investigation even was very complex. It took a lot of time. There were a lot of records. There were a lot of things that needed to be put out in a timeline or patterns so that we could understand it. It was not a simple review. I submit to you that that was exactly Ms. Kurczewski's intent. The intent to mislead and the motive for financial gain. We focused on these accounts, the top 3 belonging to Ms. Hernan and the bottom 2 belonging to the defendant. And we talked about the theft coming out of Lynn's accounts and going into the defendant's accounts. That money market account was the big account that there was $250,000 in, right? That was an account that Ms. Hernan didn't pay bills from. She didn't write a check to, We Energies from the money market account. And Detective Plentis told you why that was, because there's penalties on an account like that for too many transactions. So what you saw happening as a pattern was that Ms. Hernan would move money from the money market account into her own checking account where she'd pay bills. The only checks written from this account, aside from one, go to the defendant. No one else is getting thousands of dollars from this account. There's memo lines shown along the right side. I submit to you that the intent behind those memo lines is to mislead. Because that's not what these funds were used for. We painstakingly went through Ms. Kurczewski's spending habits. There was no IRS payment. She got a tax return that year. There were no doctor bills for procedures, endoscopy procedures. There was not huge sums of money going to car payments. There were thousands and thousands of dollars a month spent at Stalis Palace. That's what you saw on the defendant's finances. A bank account that held $250,000 less than 2 years later had $87 and change in it. and $134,000 plus of that money went to the defendant in the form of 20 checks. The last two entries on here were electronic checks, both written October 1st of 2018, 2 days before Ms. Hernan dies. And I say written, but they really weren't written, were they? Because they're electronic. This is internet check. What's the top one for? $5,000 to the defendant. And the bottom one is a check that went directly to the defendant's mom's apartment complex. These funds came out of the BMO money market account. These checks were made online. On the same day these checks were written, the defendant, who never had a BMO account of her own, downloads the BMO Harris mobile banking app. Lynn Hernan was not creating electronic checks 2 days before she died on the internet. The other main account of Ms. Hernan's was her checking account, the 5336 account. And during the trial, we focused a lot on the checks written from the money market account and this checking account. But there were also expenditures that we didn't include in the total, including over $4,000 spent on her check card while she was in the hospital. $4,000. She was only in the hospital from September 15th through the 28th. Whose spending pattern does $4,000 in 2 weeks sound like? There was over $3,000 of transactions after Ms. Hernan's death. We know that she wasn't using her check card. And ultimately, of all the checks that Ms. Hernan wrote from her checking account, included paying bills, and over $10,000 in checks to the defendant. It's very telling when you look at two of those checks from Ms. Hernan's checking account. Ms. Hernan certainly knew how to give a gift if she wanted to. When Anthony graduated high school, Ms. Hernan's intent was to give him $200. So she wrote a check, and in the memo line, it says graduation. There's one other check in the form of a gift from this checking account. It's to Ms. Kurczewski. The memo line says gift. Look at the value of that check. $2,612.17 for a gift. Ladies and gentlemen, Ms. Kurczewski is the only person in Ms. Hernan's life getting gifts like that. There is absolutely nothing in this record for you to conclude that people like Anthony stopped caring about Ms. Hernan or that she stopped caring about him. Absolutely nothing. This makes no sense because the date of the $2,600 that Ms. Kurczewski got was July 22nd of 16. She didn't graduate from high school that day. She didn't get married. She didn't have a baby.
I'm going to object to information that's not in the record, Judge.
Overruled.
We have an objection.
That check is not to celebrate a monumental part of Ms. Kurczewski's life, like the $200 that Anthony got when he graduated. When you add up these checks, you get that total that we talked about before. And ladies and gentlemen, that was Ms. Kurczewski's primary source of income. Right? You saw her paychecks over the span of almost 2 years totaled less than 50 grand. Her income was stealing from Ms. Hernan, and she never paid a dime of it back. This total of over $144,000 does not take into account several other pieces that are very suspicious in this case and give another piece of circumstantial evidence for you when you consider, is this really what Lynn wanted? In February of 2018, a loan is applied for 30 grand is what ultimately gets approved. At that point in time, Ms. Hernan is not in some sort of dire financial situation. She's not trying to buy a home. There's absolutely no reason gleaned from Ms. Hernan's financial accounts that she would need this kind of a loan in February of 2018. I submit to you that the way that this loan was applied for, that's not something that Ms. Hernan was capable of doing, frankly. Because these documents on the left, this kitten check, I've highlighted the last four of the account number on the bottom of that check. That was given to Goldman Sachs to say, here's the account we want this money to go in, right? It has Lynn Hernan's name on it, but that's the defendant's account. The 8149 account did not have Lynn Hernan on it when this application was made. And what that means to you, ladies and gentlemen, is that that is fraud. It's not real. That check is not real. What else isn't real that Goldman Sachs received? We went through painstaking detail about the different financial banking support documents that loan provider received. Again, they're fraud. They are fraudulent. Someone who knows how to create documents and manipulate information turned the bank account information of herself to look like it was Ms. Hernan's. The information that Marcus Goldman Sachs was given during this application process includes that phone number that we've talked about, 262-421-5290. Detectives told you that is not a number that Lynn Hernan used. We know one person that used that number, and it was the defendant who gave it over the phone to a bank when she was pretending to be Lynn Hernan. The intent behind this is to mislead. The motive is financial gain. Ms. Kurczewski has to then add Lynn Hernan to this account before the money is dispersed because the loan is in Lynn Hernan's name. So the money gets put in to Jessy Kurczewski's account on March 8th of 2018, $30,000. And this was all done online. Ladies and gentlemen, Lynn Hernan knew how to give gifts if she wanted to give gifts. There are such more simple ways of transferring money to someone than this. And that circumstance goes directly to consent. That loan ultimately has some payments made from the estate account. Right? Goldman Sachs is saying there's minimum payments due on this loan. The defendant pays 3 times out of the Tri-City account, all the while having never listed that $30,000 loan on the final accounting. Ms. Kurczewski never discloses it. She never pays it. I submit to you, ladies and gentlemen, that's because her intent was to mislead and her motive was for financial gain. We know Ms. Kurczewski is accessing these accounts without Ms. Hernan, because this call placed near Ms. Kurczewski's mom's house is a call to the bank. If we could play that, please.
Thank you for calling City. My name's Melanie. Can I have your name as it appears on your card?
Lynn Hernan.
This is another circumstance for you to consider when you're trying to determine whether all of this financial activity was done with Ms. Hernan's consent. If she's with Ms. Hernan and Ms. Hernan wants her to have all this money, why do you have to pretend to be her on the phone? There's evidence in this record that Ms. Hernan knew how to make a call to make a transfer of funds, to talk to her bank on the phone. There's absolutely no logical reason why Ms. Kurczewski would have to call any of these banks and pretend to be Ms. Hernan. The intent was to mislead, and the motive was for financial gain. And that's why all of Ms. Kurczewski's information is on the victim's credit report, which the defense showed you. Exhibit 621. Ms. Kurczewski's P.O. box, her phone number, and the 5290 number are all on here. Another circumstance for you to consider in terms of whether this was all with consent. Ms. Kurczewski gave a pretty detailed account of what she and Ms. Hernan did on October 3rd of 2018, multiple times in those interviews. And when you look at these, it's actually quite morbid. Ms. Hernan is either being poisoned, dying, or dead, and Jennifer Flower gets a new 75-inch TV and an Apple Watch on Ms. Hernan's dime. I submit to you, ladies and gentlemen, that Lynn Hernan did not have the desire to have a JCPenney credit card opened up the day she died. Most or all of these things happening online, which Ms. Hernan also didn't do. At this point in time, the money market is depleted, the checking account is depleted, and the credit cards are maxed out. But there's still money for Ms. Kurczewski after Ms. Hernan is dead. Because when Ms. Hernan dies, Ms. Kurczewski then files for the informal administration in the probate estate. Her and Anthony Poza are the beneficiaries, and immediately Anthony told you that it was odd how quickly Ms. Kurczewski told him, you have to sign off on this stuff so we can get the estate going. And after that point in time, ladies and gentlemen, I submit to you that the Tri-City estate account became Ms. Kurczewski's source of income. Over $50,000 in cash went from that account into Ms. Kurczewski's pocket. It was not going to creditors. And when Anthony realized just how much money had already come out of that estate and asked some questions about it, we have a series of fraud handed from Ms. Kurczewski to Anthony Poza. The intent to mislead. The motive, financial gain. 52 pieces of paper Anthony Poza got from Jessy Kurczewski. Here's 17 of them. Fake. They're fake. The vet clinic administrator came in here and told you that's not correct. And not only was this created so that Ms. Kurczewski could pocket an extra $100, but the cats put down and their name got deleted for no reason. Fake. 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 ServPro bill. Fake. Detective Plinus painstakingly went through these documents and showed you that they're all fraud, created by someone who is very good at making fraudulent documents look correct. Mr. Poza thought, well, okay. And this is, you saw this through the handwriting expert. There's the Jeep title. Fake. Debts of decedent. Fake. These numbers don't even match the numbers that she tried to give Anthony Poza. And the will. Fake. Ms. Kurczewski knew that she had to create some reason why she had taken 50 grand out of the estate account, why she had spent another 15 plus in payments out toward other accounts. You heard testimony that there's one person involved in this case who has previously used fraud, used a mechanism to mislead for financial gain. 2 different times back in 2010. You can consider those for Ms. Kurczewski's intent and motive in this case. And I submit to you that it's very clear. Her intent is to mislead, and her motive is for financial gain. Ms. Kurczewski has a pattern of making things up to get herself out of trouble. Attorney Taylor testified that when she got involved, Ms. Kurczewski got removed as the personal representative. Ms. Kurczewski's backed into a corner at that point, right? She's not in charge of this anymore. So what does she do? What does she do to try to get herself out of hot water? She files with the circuit court this new will that removes Anthony with some, Attorney Taylor told you, very odd explanation that the first will was some sort of a test that then Anthony failed. She's never heard of that in her life because it's ridiculous. And the loan alone of $18,700 meets your value criteria on count 3. Not even considering the cash or payments that were made from the Tri-City account to the defendant's own debts. None of that inheritance loan funding is valid. That is theft. Ladies and gentlemen, you were told that personal representatives have a fiduciary duty to act in the best interests of the estate. Not themselves. Not themselves. The estate was the rightful owner of the money at the time of this theft. And as one of the beneficiaries, Anthony Poza is listed as a victim on count 3. None of that $87,000 went back into this estate account. There is an intent to permanently deprive. Ms. Kurczewski didn't pay any of it back. And ultimately, Mr. Poza receives a check for 13 grand, which was half of what's left after Ms. Kurczewski stole from it. Again, you can't read someone's mind to determine intent. But the case comes down to intent. All 3 charges, right? Because Ms. Kurczewski says, I didn't steal from Ms. Hernan and I didn't kill her. But this is again where you're going to have to make some credibility determinations in the face of so much circumstantial evidence. Because, ladies and gentlemen, lies are very tricky to keep track of. The truth is very simple. And in this case, we've shown that Ms. Kurczewski lies when it will benefit her. When she's in hot water, she lies. Ms. Kurczewski compartmentalizes people in her life to keep them all from the truth of what's actually happening. And the intent behind this is to mislead them. And the motive is her own personal gain. Throughout this case, the question of whether Ms. Hernan was suicidal changes multiple times. On day one, on October 3rd of 2018, Ms. Kurczewski is not telling any EMS worker or deputy, oh my gosh, she's been drinking Visine, she had a gun once, she's been trying to kill herself, I can't believe this happened. No, she's asked, point blank, was Ms. Hernan suicidal? And the answer is yes and no. But after this date, what do we know about Ms. Kurczewski? She's very interested in what the medical examiner knows and what the sheriff's department knows because she's calling. What's in the toxicology? Do we have the toxicology back yet? Until they finally tell her, we can't talk to you anymore. So she comes in and talks to detectives. This entire discussion on Ms. Kurczewski's point is to mislead them. She's not going to reveal she poisoned Ms. Hernan with tetrahydrozoline because she doesn't know they found it yet. She doesn't know that anybody knows what she did yet. So she's not going to bring it up, just like she didn't bring it up on the day it happened. Maybe they won't find it. Then we have the star. July 9th of 2019, when Ms. Kurczewski is finally told this.
I'll be honest, there's been 3 times that she said, I want to give up.
Yeah.
I don't want to do this anymore. And she always said, the day when it comes, I want your help. The day when it comes, I want your help. I said, I'm not helping you do anything. When it comes to pills or messing around with anything, I'm not looking for trouble. I'm not trying to get in trouble.
But
She's a full-grown adult.
Like our doctor from Waukesha.
So that's a pretty different story than that. As soon as she knows the gig's up, well, okay, 3 times she said she wanted to give up. Ms. Kurczewski is constantly considering the new information that she's getting and altering her story in a way that benefits her. The next day, she wants to talk to law enforcement. I want you to remember that. All of these interviews are because Ms. Kurczewski thought about things overnight and wanted to give more information the next day. So the next day, the question of was Lynn suicidal changes again.
Because she was trying to find an easy way out.
She did
the pills first numerous times. That wasn't working.
So she was trying to kill herself by drinking Visine and Vodka.
She also bought a gun offline that I disposed of for before she died too.
When? How long?
Oh, 2 months.
I submit to you, ladies and gentlemen, that Ms. Kurczewski knew, well, they found it in the toxicology now. I have to say she was suicidal and that she drank it on her own to keep myself out of trouble. The intent behind all of this is to mislead, and the motive is to keep herself out of trouble. These focus over here. She bought these guns, right? Misleading the investigators. There's these guns. She bought them. I wrestled one away from Ms. Hernan once. Okay, well, Ms. Kurczewski is really the person, based on the evidence, that acquired those items. The Brownell firearm, here's the phone call. Hey, I want to change the delivery from a residence to a FedEx pickup. That phone call is made from Ms. Kurczewski's phone near her house. And this is all in order placed on Ms. Hernan's credit card. This one's even more telling, because what do we know about September 27th of 2018? Lynn Hernan is at Waukesha Memorial Hospital, which is nowhere near the map that you're being shown from Exhibit 173. This is a phone call to Urban Arms. Another order using victim's credit card. She's in the hospital. And the order is made on Ms. Kurczewski's phone. That's all nonsense. It's all an effort to mislead. Because in reality, Ms. Kurczewski's story changes iterations based on the amount of information that she has. And the only things that never change are things that only Lynn could correct. That she was suicidal and that she wanted to give all of her money away. I'll say again, credibility is a huge task for you in this case. And when we talk about someone's credibility, you've seen firsthand things that Ms. Kurczewski has no problem lying about. Dan Radloff sat up there and told you that she would pretend to go to work when he was living with her. She would get up, get ready, and pretend like she had a job. Later saying, yeah, no, I'm not actually working. Up to big lies. Like a lie to a family she lived with. Why did the Craig family think Lynn Hernan was in a coma at Freighter? This is why. Because Ms. Kurczewski told that to Scott Craig. And remember why this comes up. In May of 2018, what's going on in Ms. Kurczewski's life that makes this lie something that's going to personally gain? She's going to gain from. The scenario is that Scott wants nothing to do with her anymore. And it's all an attempt to mislead, to shift your focus. Scott, forget about that and look over here. Lynn Hernan's in a coma. She was never in a coma at Freighter Hospital, and Ms. Kurczewski never told Scott Craig that. The detectives told Scott Craig that. The motive is to get herself out of hot water. And nonetheless, she lies about telling them that.
So I'd be out by her.
Again, this is a guy who swears he's told me she was in a coma.
No.
Why?
I never said that. Swear to God.
Why do you think he's so upset?
This is someone that she was closest with. She lived with. Scott Craig was also someone in Ms. Kurczewski's life that had to stay very compartmentalized. It is no coincidence that he never met Lynn Hernan, ladies and gentlemen. It is no coincidence that Scott Craig was not invited to the funeral dinner for Lynn Hernan, where Scott may have been able to talk with an Anthony Poza or a Keith Lang or a Corrine Poza. So sad about Lynn being in a coma at Freighter. Can you imagine if Scott would have said that at the dinner? No way. This was something that was so significant because he had no idea. Ms. Kurczewski was very, very good at misleading Mr. Craig. And he expresses the frustration and shock in this call that you heard from State's Exhibit 54.
I was told she's in the hospital.
Your best friend was in the hospital numerous times.
Well, not in a coma for 5 months. That's what you told me. So,
I know that's what I told you.
Yeah,
I told you
I know.
that to protect you for a reason.
I told you that to protect you for a reason. That makes no sense, ladies and gentlemen. Another consideration in your credibility determination of the defendant in this case should be this January 2019 discussion, which happens up here on our timeline, well before the star. What is going on this day in January of 2019? Do you recall the beginning of this discussion? Scott Craig's mad at her. She's in hot water again. Right? However, that disagreement evaporates once she says this. Tetrahydrozoline in my blood. Detective Cole couldn't even pronounce the word tetrahydrozoline. And Jessy Kurczewski is spelling it out in a text message, pretending to be at the hospital. She obviously goes on to ever deny saying this in 2019. And then changes that story to, okay, it was a friend, and then changes that story to, okay, I actually drank it, but no one was really poisoned. But the main point that you need to consider, which bears on intent, is that in Ms. Kurczewski's own statement, she knows exactly how serious tetrahydrozoline is. And she's right about that. Because you heard testimony in this case that when used for nefarious purposes, perpetrators select tetrahydrozoline because it impairs memory, impairs judgment, reduces inhibition, produces a period of unconsciousness. It's not routinely detected, and it's available. Nonetheless, 6 months later, when Ms. Kurczewski is told, this is her response.
I get it.
And there's an anomaly in her toxicology. There's a drug in her system that's not supposed to be there.
And what would that be?
It's called tetrahydrozoline.
What is that?
Commonly known as eye drops.
This is six months have gone by. So now she knows. What does she say about whether Ms. Hernan was using it?
A lot. Like not enough, you can't take it through your eyes. It has to be ingested. Through orally.
I've never seen her drink it. Ever. Ever. And why would you drink eye drops? I mean, what would it taste like? I don't even know, but...
Not, oh my gosh, I've been buying bottles of this stuff for her. Because she drinks it all the time and I've seen her drink it. No. It's...
See it like that because it doesn't sound right, but I didn't give her anything. I didn't even give her pills wrong or vodka or drug. I didn't give her anything. I didn't give her this eye drop.
Then we have a period of time where Ms. Kurczewski is thinking, and the next morning she says, I want to talk again. Right? This is the next day.
I've gotten the Visine for her. I never put any in her, anything for her. Ever. Ever. Never. I bought it for her. That's as far as I've gotten. I've never even put it in her eyes for her.
I submit to you that the intent behind this is to mislead, and the motive is to get herself out of trouble. Or this would have been something she said on day one.
And she was drinking vodka and Visine.
Now, how do you know she was drinking vodka and Visine?
Because that's what she had mixed together. And that was the day before.
How do you know she had mixed Visine with her vodka?
Because that's what she did.
There's still some distance there, right? That was the day before. Again, there's a night that goes by. Ms. Kurczewski is thinking. And the next morning, on the 11th, I want to talk again. I've got more information.
She did, one time, the whole time I've known her, she drank one bottle in front of me. Just one time. One bottle. And she never did that afterward. I was so upset and hurt by it because I didn't want her to do this. I didn't think it was the best way to go. She was trying everything.
2 days ago, this person is saying, I've never seen her drink it ever, ever. And now she's drinking a whole bottle of it in front of her. This is the same day.
The water didn't taste like anything in the vodka. She liked it because she got like a little more of a buzz off of it.
Ladies and gentlemen, not one doctor or expert told you that that is factual at all. Dr. Thomas testified that she is unaware of anything that would suggest people are drinking tetrahydrozoline because of some euphoric or buzz. Dr. Bedritsky said the same thing. Even Dr. Spiller said that's not a symptom or side effect of drinking tetrahydrozoline. Again, the intent is to mislead.
Knowing she wants it.
Once I put in 2 drops for her.
Okay.
Once.
In what?
In her vodka.
Okay. And once was how long before that?
That was a month and probably 4 weeks. 3-4 weeks before. That was the only time I ever did it.
Ladies and gentlemen, when you determine credibility, you have to consider whether the source of the information has an interest in the outcome. This is the last version that you're left with.
Oh.
That bottle of water right there had in 6 Visines.
How do you know that?
Because that's what she put in it.
When?
She told me. The 3 days before I threw it out. And she asked for it that morning.
Did you gave it to her?
Yeah.
I ask you, ladies and gentlemen, can you even rely on that?
Probably not.
Credibility is again questioned as we begin this wild goose chase. On July 12th, there's the first little piece of information about things that are hidden away. And before you even dive into this, I want you just to think, why in the world would someone hide these types of items? Nonetheless, it starts with the BMO lockbox.
Get me out.
Okay.
That's what I'd like.
Okay.
Check her BMO Harris. Her BMO Harris bank.
Okay.
She has a lockbox.
I thought you said this was a storage shed.
That's where she put her items. No.
This is a BMO Harris lockbox now.
Correct. I didn't give any specifics for a reason.
You said a storage shed.
I said it's not in my name.
So in a lockbox, there is a gun.
No.
There is. Where's the gun?
I said she has her stuff and I have my stuff.
Ladies and gentlemen, on July 12th, when Ms. Kurczewski tells Aaron Hoppy to look in that BMO lockbox, she absolutely knows it's empty. Because she was the last one there with her mom the day after Lynn Hernan died. And in April of 2019, before these interviews, she surrenders that box, signing that there's nothing in it. Shift the focus. Look at things that don't matter. She has a new layer to this whole story then.
Tell us where you buried this stuff.
No, I'll tell you.
Where'd you bury it?
It's in Whitnall Park.
Whitnall Park?
That's where my buddy used to be buried. It's behind my mom's apartments.
Again, why, instead of telling anyone what happened, I'm going to keep it quiet, and I'm going to save some of this stuff in case Lynn Hernan does die, and then after she's died, and I've lied about how she died, I'll have it buried. You can't even connect it in a logical way if you try.
It does get muddy and swampy certain times of the year. It wasn't when I went. I did this literally before she even passed. And it was all together in 3 Ziploc bags.
Or is it in a box or anything?
Nope.
Or it's just
3 Ziploc bags. I just kept Ziploc bagging it and then the freezer bags.
And how far down?
I would say about 4 to 5 feet.
4 to 5 feet?
Yep.
Are you kidding me?
4? I don't know. I guess.
4 feet?
Hold on.
You understand? You're just over 4 feet.
Okay, like this. What is this? I'm not good with
Okay,
that.
that need 2? Okay, holy shit, I'm like 4 feet.
Yeah, I guess you're right. That is like my...
Man, when you put
Anyone stop?
If you give me 4 to 5
body
feet
in there or something?
I'm one of those people sometimes, like, I'm better, like... I have the
I'm
roads. Like, I can't tell you roads, but I can show you. Yeah, I guess that's true. I'm 5'11".
Ladies and gentlemen, Ms. Kurczewski is not stupid. She knows the difference between 5 feet and 18 inches. But Detective Hoppy wasn't buying it, so the story changes. Law enforcement attempts to find these things every time she says they exist. Metal detectors and detectives out in parks looking for rocks over burial sites. Her initial claim of a storage shed somewhere comes up again on the 16th.
Storage shed, Jessica. I know there's a storage shed.
There isn't. I swear to God, there's not a storage shed. I put that in everything. I just said that because I thought by saying that would help me get out. I swear to you on everything.
She thought it'd help her get out of trouble. That's why she said that. Ladies and gentlemen, the reality of Jessy Kurczewski looks a lot different than this person in Exhibit 206 crying about a lost burial site. The reality of this person, her acts, words, and statements, is that she is accessing documents about criminal poisoning in July of 2018 and deleting them in February of 2019. Household poisons. Arsenic trioxide. Ladies and gentlemen, what else do we know happened right around February of 2019 in this case? Right in here. The medical examiner wouldn't talk to her anymore. The reality of this case, ladies and gentlemen, is that this is someone with a fair amount of poison research on her own phone. This is someone who has profited over $144,000 before death and over $80,000 after. This is someone who misleads others when she's in hot water. I submit to you, ladies and gentlemen, that Ms. Kurczewski thought she would get away with this or be able to talk her way out of it. But the reality of this is that the cause of death is a poisoning, and the manner of death is a homicide. At the time Lynn Hernan died, she was worth more to Ms. Kurczewski dead than alive. And this person that you heard about, this loving person on the left, did not kill herself. Based on all the facts and evidence that you've seen, the state is going to ask that you return 3 verdicts of guilty in this case. Thank you.
All right, thank you. At this time, I'm going to give everyone just a short break, about 10-15 minutes. If you need a little longer, that's fine as well. And we'll come back for the defense closing arguments. All rise for the jury, please.
Okay, here we are behind by a minute, so I'm going forward. If I can. Don't mess it up now. Listen, stream. Ah, we're looking at that. Now we've got fluff, you guys. I'll put a new poll up for you. Okay, wait. Mic check. Sound check. Hello. Listen here. Don't buffer over here. We don't need buffering. Okay. So just hold on one second. Let's take this off and we shall wait. Okay. How do you think the state's, I said closing statements, closing arguments is what I meant, of course. How do you think it went? Incredible, good, not too bad, or not so great? Okay, let me quickly refresh this page because, you know, As you can see, YouTube is buffering all over the place. If it is buffering for you, make sure that your app is updated, that your cache is cleared, and all of that. Okay, here we go. We're gonna, yes, we want to put it like this. Also, in comparison, compared to the court sound, I might be a little bit softer. You might have to turn up your volume now because I boosted the court audio for us so we can really hear it very well. Like super loud, okay? Yes, you guys are saying, right? Who's that guy? You mean the guy at the back of the courtroom, right? He is grinning his butt off. I wouldn't be surprised if someone suggested earlier in chat if she's wronged him in some way and he's just so entertained by this the closing argument. It's just like, hell yes. Okay. So I've turned it up to the max here. Check, check, check. Just get used to the sound, okay? For me, compared to the courtroom. All right. So I think it was pretty good. What do you think? I thought it was a really good closing argument from the state. Now they're taking a quick break and then they're going to have closing arguments from the defense. I think it's Attorney Kuchler that's going to be doing the closing arguments for the defense. And then there might also be of course, a rebuttal then from the prosecution, which I look forward to that as well. Ooh, Nikki Ulker said, is it 4 stars? Did you get 4 stars, state attorney? Okay, not 5 stars, 4 stars. Or did you mean 5? Okay, I cannot believe that Jessy Kurczewski is sitting there going wrong and like no and all these things she's doing. Like, Jessy, zip it, okay? This is not the time. Remember back then I was saying, wow, she doesn't have any, like, nothing on her face, no emotions. I wonder if over the weekend her defense team watched the streams and they were like, show a little bit more on your face. Well, not now. Not at this moment. Not after you chickened out of testifying. No, this is not the time to now make faces. Zip it. Keep your face calm, lady. So let me quickly see if there's some comments that I missed earlier. There we go. It was calcification that said earlier, the guy in the back is probably there to witness her downfall, perhaps. I bet she's got a wake of wronged people in her past. Probably, right? And also Babs Austin said, if I'm on the jury and I see Jessy's behavior, I'm thinking, you should have testified if this isn't true. Yes, exactly. That's not going to convince anyone. TMCB girl. Girl 007 says, lock her up. Or as we say, cuff him. Cuff them. I can't wait till they perhaps do that, although she's innocent until proven guilty. But I think the evidence is stacked up against her, right? Okay. I'm really enjoying watching the closing arguments with you. Of course, we are live today compared to the way we covered the trial throughout from day 1 to 13. Day 14 was the judge talking to the attorneys, which we didn't cover together. But yes, today we are with all the fluff. At least for the other days, we had no fluff, straight through, right through the teleporting. We can't teleport now. Our teleport machine is charging. There we go. Peniel says, cuff him. Exactly. Okay. And earlier, TMCB Girl 007 said digital breadcrumbs are tasty. And they are. There's a lot of digital breadcrumbs to show Jessy her own behavior like a mirror today. Yes, Jessy, you see that? Which is why I think she's so animated today. It's really summarized. Like, yeah, look at this. While Lynn was in hospital, look at all the money that was being spent. Even after her death. Wow. Yeah, Daisy Jail says, I'll be surprised if Judge Dorrow doesn't tell Jessy to refrain if she continues. If you guys didn't know, I'm sure many of you have been following this trial with me. Know now, Judge Dorrow, if you remember, she was the judge presiding over the Darrell Brooks trial yesterday, just for fun. Okay, I watched day 1 again. Oh my word. This judge, the patience that she has, it's incredible. If you've never watched the Darrell Brooks trial, just look at day 1, opening statements, because he defended himself, right? It's like, within 5 minutes, it's just like, shame, how did she get through this trial? Willow Wren says, not sure if I can bear the defense closings. Thank you so much for your sticker. You know why you can? Because you're here with us. We're all going to do it together, okay? We're going to, if it has to become a bit of a snark tank, we won't go wild, okay? But if we're feeling snarky, we're at least together. We'll be like, what on earth is this? I think they're going to go with the assisted suicide angle because they specifically talked about that on day 14, which we did not cover together, but I lurked on there and like, what are they talking about? And they wanted that in. So, yeah. Okay. And what else? What else? I think those are all the comments that I got earlier. Yeah, Willow said, I'm surprised the judge hasn't shut down Jessy's shaking head and mouthing words. So I think she wouldn't at this moment interrupt that. But I wouldn't be surprised outside of the presence of the jury if she admonishes her. Oh, I already had that one. Debbie F says, mother is an enabler or an accomplice. I wonder, and I did hear that door slam, and I did then see, okay, the mother's not there anymore. So did her mother really walk out? Did she have to go somewhere? Important call to make, or what happened there? Not that. Mickey, thank you so much for being a member for 3 months. You said, enjoying this day on a live with Grizzly True Crime. Love, hometown Grizzly. Damn, cameraman. Okay, we see you, cameraman. You're a Grizzly. We know it. If you remember from Letitia Stark's trial, we were like, cameraman. Listen, cameraman. I think they were watching a little bit. All right, remember that. Okay. So let's see what I wrote down here. That's what I was looking for, by the way. Shame. These poor pens. These pens will have to be retired. They're done. So if you saw me like scratching around earlier, I was like, let me find a pen that actually has ink in it. So there we go. Okay, so let's see. They went over count 1, 2, and 3. So if you didn't know and you're only joining now, yeah, Jessy is facing 3 charges that the jury will have to deliberate on. So sometimes that can take longer, you know, when the jury has to deliberate on multiple charges. One is for first-degree murder, and the other 2 are for felony theft. Count 2 was for theft while Lynn was alive, and count 3, theft after Lynn's death. They said we must, well, we are not the jury. The jury, okay, we can be the public jury. We can be the mock jury, right? Cork B, welcome to Grizzly Supporter. Make sure you check out the member stream we did yesterday. I think it was yesterday, last night, right? Yes, it was. It feels like it's been ages already. So they said, the state, attorney Abbey Nickolie said, motive versus intent. So they don't have to prove motive, but they're thinking of the intent, you know, even though this case is obviously, it's a lot of circumstantial evidence. And they made sure to remind the jury, just look at the credibility of, does this person have any credibility? And then they showed all the clips, which that's why I showed the trigger bunny, because damn, I don't think we're going to hear that voice again today. I'm glad they did show it, but I really like their presentation time. And I'm glad I found a live stream that doesn't have the you know, logos blocking the presentation time, which was so nice because we could see the whole thing then, right? Okay. Denny Dawn says, maybe her mother knows now with all the stuff her own daughter did to her bestie. If she was not involved, I hate to blame her mom, but she was no friend to poor Lynn like she said she was. You never know. Yeah, everyone's thinking maybe they should look into Lynn's mom. Jessy's mom next. I wonder. You see that sometimes. Remember with Tristan Bailey's case, if you didn't follow it, don't worry. It's there for you to check out if you want to. But Aiden Fucci was first, he pleaded out, right? He pleaded guilty last minute before his trial was set to begin. But then his mom was charged with stuff after that, a whole bunch of other things, right? So my point is, sometimes, example, Jessy's on trial now. Let's see what happens. What will the verdict be? Maybe if they're thinking that her mom should face charges, it'll probably be after that, but who knows? Okay. Annie T says, I am getting the snark meter ready. I wanted to show you something as well. Let me just quickly finish reading this. They say that the truth is very simple. And of course, Jessy's lies are not. It's very difficult to follow her lies. But they said the truth is very simple. And Jessy tends to lie when it will benefit her. And you can see it happening today in court. When she's like, wrong, of course. Now it would benefit her if anyone on the jury believed her. If anyone was watching her and thought, wow, but she's saying that they're wrong. I don't think, you never know. I don't think anyone believes that. Then she should have taken the stand, honestly. And so, yeah, I wrote here, Jessy had a chance to speak. Yeah, she did. And remember the story with the storage box? Then it became a lock box. Then it became a buried box. Even that. Wow. Okay, so I am monitoring the stream. What I wanted to show you quickly was, I want to show you Lynn Hernan's tribute video. So I'm going to play that quickly, just to remind us, especially before this defense closing arguments begins, what we're here for. And to Lynn's family and friends that are watching here with us, I hope that you feel safe here with us, the Grizzlies. We've got your back, and we are here to support you. All of Lynn's family and friends, I really hope there will be justice for Lynn I hope today, maybe tomorrow, I hope they will be. I hope it will be guilty on all charges from everything I've heard. That's my personal opinion. Judy Sanders said, what a day for my anniversary. I love this channel. Happy Grizzly anniversary, Judy Sanders. So I don't know if I've got the tribute lined up now as I switch to the next thing, but I'm going to, whatever I've got there, I'm going to pause it and then I'm going to play the tribute, okay? So here we go. I'll be right back. Please note that okay, now I'm back, everyone. Lenny, oh my word, you have been a member for 24 months. That's almost as long as I've had my channel. Thank you so much. You said it's good to be back after being in hospital. Thank you for covering this trial, Gisela. I hope that you feel better, Lenny, and thank you for being here with us. I also want to quickly show you, I don't know how long this comfort break will be. You know, Donna Kuchler wants to prepare herself, even though you had the whole weekend to prepare, lady. She wants to prepare herself for her closing arguments. So what I did for you, something I wanted to do for a while, is let me show you quickly, and they'll probably come back as I do this, won't they? Wait, I will have to make it. Hold on. It's gonna have to be on top. Yeah. Okay, so what I've got here for you is pure fluff, just for you. Pure fluff. Examples of the fluff we cut out before. So listen to this. I made it for you guys. Yes, got some courtroom ASMR. In case anyone's just joining now and they're like, what are we watching? Trial fluff, just for you. Ooh, I think they're coming back. There we go, perfect timing. Thank you, Miss Holmes.
I can't see what anything is.
Are we ready for the defense's closing arguments? Oh boy.
Is it on your screen? Yeah. Sometimes you have to duplicate, remember?
Yep. Do I need to do that now?
No, I mean, I can see it.
I can see it everywhere. Okay, good, great.
Okay, so bring it out. Yeah. It's off for now, so it was working.
Okay, I was just preparing the text for you. Defense's closing arguments. Attorney probably Donna Kuchler. If it's not her, I will change it. Essen, and I have more where that came from. Maybe I'll put it on Patreon. Special treat. Oh, everybody, buckle up, buckle up. Jessy's buckling up. She's like, oh. She's now going to agree with her defense attorney. Like, that's right. That's right. We're probably going to see that now. Oh, boy.
Can you check to make sure the boards don't block any table view from the jury? You shouldn't block anyone.
We've got free fluff right here. Look at Pablo's face. Shame.
No, I don't think it does, but I'll double check.
Yeah, I don't know if the state wants to check too. I just want to make sure that everyone in the jury box can see both tables with those large. I'm more concerned probably about the end.
Just turn the sound off for a second there. Sue says, too bad you can't speed up the defense's closing arguments. I know, right? We could if we just waited a while. There'll be no point to that, but then be like, oh, okay, let's catch up at 1.25 speed. Yes. Isolde says, love Judge Dorro. D. Keller said the cross necklace is beyond the pale. Okay, let's hear again what's happening here. Oh, she's getting her tissues ready.
I think we're ready to go. And all of our...
Yes, Joy.
I know they went up to a different floor for some of them, so I think they're all back, and we'll bring them out shortly.
Okay. Elbo's mom says, I'm peeking from between my hands with my fingers in my ears.
Okay, let's go back on the record then. Appearances are as they were before. Just before I bring the jury out, I had another thought related to 28. I can do one of two things, is excuse him and then he would not have to stay with the others, or keep him. I don't know that I've ever been in a situation where I've actually needed the alternates, but you never know. Does either party have a preference on that?
No.
Attorney Kuchler?
I mean, no, not really. Whatever the court wants to do.
Then I'll probably excuse him and I'll let him know.
That was a new tone,
So
Donna.
I'm thinking about it, then that would look like it's different than the other jurors. If one is excused and the other two aren't, it looks like there's some kind of differentiation.
Well, I would do that on the record in front of everyone and just tell him. But otherwise, no, that's fine. We'll keep them.
Okay.
Whatever you want.
I think we should keep them.
Okay, then that's what we'll do. All right, Madam Clerk. That's a good point, so.
We've never heard Donna Kuchler say whatever the court wants to do. We've never heard that. We heard it here today. Here we go, everyone. Got fluff for you. Jury's coming back in. Yes, please let them not victim shame.
So, you have.
Thank you all for being here. Please like and share. Make sure you subscribed, and then let's get more people over here to watch with us, because we're going to need support. Call for backup, everyone. Share.
I will just copy. Yeah. Unless they can figure it out. I just can't see. Right.
Caroline, did you see the fluff that I made for you? You suggested it. Then I'm like, I should do that.
Thank you, everyone. Please be seated. And then, Attorney Kuchler, when you are ready, you may begin.
Here we go. Buckle up. Buckle up, everyone.
Get my screen up. Ladies and gentlemen, this case is not a homicide. The state has not proven a first-degree intentional homicide. It's what everyone concluded on October 3rd, 2018. It was a suicide. And Everyone who came to the scene on that day concluded it was a suicide. And they concluded it for a lot of reasons, including what you saw, which is a whole boatload of prescriptions that were laying around. Lynn was hoarded pills, and they were everywhere. Pills that were no longer prescribed to her. And the pills were found in her system. She took all those pills. And also, when the medical examiner did the evaluation of the stomach contents, pills were in there. It's what is called a polydrug overdose. When somebody takes too many pills, the combination together can create exactly what happened here. That is Lynn's death. And Dr. Thomas, when she was here, she said there was strong evidence. Let me see what I've got. This is the prescription medications in the living room. And I don't want to forget about what was at the scene. Remember, people who were there that day weren't looking for eye drops. That wasn't on their mind. So the suggestion that there were no eye drops is not true. It's not proven by a fact. It's just an opinion. And when the people came in and testified, law enforcement, they agreed with us that they weren't looking for them. And Dr. B agreed 100% eventually that there was a bottle of eye drops, albeit not the ones with tetrahydrozoline, the ones that she would use in her actual eyes, on the table next to her. But if you remember at the beginning of the case when the state was asking witness after witness, were there eye drops there, were there eye drops there, were there eye drops there, the answer was always no. But it wasn't true. And what was surprising is that even after Dr. B agreed that we had found the right bottle of eye drops that were on the table, that Detective Hoppy, when he got on the stand and he sat through this entire trial, still couldn't agree that there were eye drops at the scene, even though it had been testified to by the state. But it's similar to the deputy medical examiner when she looked and she saw the kitchen wastebasket full of liquor bottles. Nobody took any pictures of liquor bottles. She said she saw it. She put it in her report, but nobody in law enforcement ever bothered to photograph it. That doesn't mean they weren't there. That we know was there because she saw them and put it in a report. Otherwise, they would be here today also arguing that there was no sign of any liquor. They weren't looking for it. But they noticed things that were all consistent with a suicide. There's the bottle of eye drops.
Until the autopsy.
Identified it. We brought in the bottle. Those are eye drops. It wasn't collected. So the state says that they collected all this boatload of stuff. Well, how about that one bottle that was right there on the table next to bottles of pills? Of all the things you wouldn't collect, why wouldn't you collect that? To make it suggest that they weren't there? Thank goodness for one picture where we can find it. Because it wasn't collected doesn't mean it wasn't there. Because Visine or other types of eye drops that also have tetrahydrozoline in them, and there's any number of them, you saw them as exhibits during the trial, just because they were not collected or noted doesn't mean they weren't there. She had tetrahydrozoline in her system. Now, Lynn had water bottles. There's one. We can see caps for 2 water bottles. We don't even know where the other water bottle is. Again, not collected. Certainly, these things should have been collected, should have been available to be analyzed. You're going to charge somebody with the first-degree intentional homicide, and yet you don't have the evidence to be able to test it, to look at it, to evaluate it? sorry. Everyone at the scene concluded it was a suicide, ladies and gentlemen.
Until the autopsy.
It was a suicide. It looked like a suicide. For Dr. B to say a year later that the scene looked staged, how can we wrap our heads around that? If the scene looked staged, then on October 4th of 2018, when she did the autopsy, she should have been right out of the gate. Look at this scene. It looks staged. Because part of her autopsy, right, it was to look at all these photographs that had been taken at the scene by her deputy medical examiner. And the facts and circumstances, look at Lynn's body, look at how it was positioned, the drugs that she had spilled on herself. She saw all that on October 4th of 2018. She had a body next to her to compare the body that's next to her with what was fresh evidence. Hey, law enforcement, this looks staged. I want you to rush over to that home. I want you to go look to see what else you can find, because I don't think this is a suicide. She didn't do that, because it didn't look staged, because it wasn't staged. And the suggestion that these fragments or powder or pills that Lynn was obviously using to be able to take the drugs she decided to take, that because they were spilled in such a way it's staged. No. Dr. Thomas explained it's much like eating anything that has crumbs, right? Whether it's a powdered sugar donut or something else that you're eating, and you've got crumbs, they spill on you. And there's no way to say that way the body was on at the scene, that there was no jostling or movement of that body between there and getting it to the medical examiner's office, because of course there was. Dr. Thomas done more than 5,000 autopsies. She's so very experienced at this. Said there's always going to be jostling of the body. From pulling her out of the chair, to putting her on a gurney, to putting the body in a body bag, to taking it in the car back to the medical examiner's office, and all the things they have to do. Of course, the body was juggled and jostled. Now, when the medical, in the trial, with the Plainview eye drops that were never gathered, that we established in trial, that nobody ever noticed, because remember too, Dr. B, when she first testified, said there was no evidence of it at the scene. It's only when we saw it that anybody else saw it. If you're not looking for it, you don't see it. We learned, though, that in her belly, we learned through Henry Spiller, didn't we, that in her belly was a teaspoon of Visine. 1 teaspoon of Visine. And we looked at a bottle of Visine, and we learned that a teaspoon is about 1/3 of a bottle. That's how much was in her belly. Dr. Thomas looked at the scene, and that's what, you see, that's what, when you get a second opinion on a cause of death and a manner of death, what the second pathologist does is really take a look with fresh eyes at everything. And what she looked at were the same things that Dr. B looked at. No, she didn't have the body in front of her, but there's nothing about having the physical body in front of her, of Dr. B, that led to any conclusion that Lynn died of tetrahydrozoline poisoning. But what she does have is the benefit of all the scene photos, all the autopsy photos, which we didn't show you, but there's dozens and dozens of them. As the medical examiner is doing her evaluation, she takes a picture of everything along the way. So that if there is a second evaluation done, the second pathologist can see what she saw with her eyes. She also had the slides. She also reviewed the slides. She also has the toxicology and the reports and the medical records. She had all of that. And she told you that it is undetermined, but strong support for suicide or even an accident, which can happen. Somebody takes too many pills, the wrong combination, can accidentally die too. As far as it being staged, this is what law enforcement said. Oops, just a minute. I don't know if we don't have volume for some reason.
Plate and spoon away from her, but I've also brought back to her because there were certain pills she couldn't swallow. Physically, she couldn't. I mean, we'd sit there and they'd come back up. Sit there and they come back. So, I mean, it went both ways. As far as the pills she crushed, I mean, I didn't sit there and let her crush 20 pills in my presence. You know, I let her, the main few that she always did. Usually if I come back, there'd be more or different ones, or, you know, you can tell by looking at a plate. You know, obviously if they're all white, you can't tell. But, I mean, I'm telling you, I know when I left every day, and I'd come back and the pill amounts aren't what they should be. And then she always kept pills on the side of her that she didn't take anymore. And those were suddenly getting put up on the table, and she'd, I grabbed those by mistake. You know, she'd make up stuff. And she'd act like she didn't, you know, like, I didn't put those there, or...
Lynn crushed her pills. And Jean Tennell, the neighbor who the defense called in, said that when she would see Lynn, she was usually drinking 2 bottles.
Ooh, we got some pepper.
2 bottles of water. And she told law enforcement back then, despite what she might have remembered in court 4 or 5 years later, at the time that she was interviewed by law enforcement, she told them that Lynn was suicidal and alcoholic, and that Lynn wasn't nice when she was drinking. Of course, Lynn was nice many times. Of course, just
I appreciate the buffer. Buffer rich. We like that. Is it going to help us teleport or speed it up? I've just paused it for a second now. Freaking YouTube. Okay, let's continue if we can.
He had a very good relationship with Lynn, and other people at times did, but when Lynn was drinking a lot or maybe using a lot of drugs, she wasn't a nice person to be around, and Jean said that.
She didn't say that.
And the alcoholism is supported by the medical records. Remember, she had the signs of alcoholism that were seen by Dr. B and testified to.
No, she didn't. Sorry, I have to interrupt this. Like, no, it wasn't. Those signs were not there in her liver results and all of that. And also, the neighbor Jean did not say that Lynn was not a nice person. What the hell? Oh, so is this strategy just lies? Just like her client? Let's just lie. Let's just try to convince the jury of something, right? Come on.
By Dr. Thomas. It was there. That's a fact. And remember, Lynn being found at the scene, she's got expensive bracelets on, and there's water bottles around that presumably the state's theory is Jessy was trying to kill her with THC in the water bottles. If you're going to do that, why would you, one, leave expensive bracelets on her? Why would you take those expensive bracelets off of her, right? Why would you?
She took it off later and pawned it off instead of giving it to people. Okay, sorry. I'll try to not interrupt. She did take it later for herself and pawned that off, her special bracelets.
Leave them. And why would you leave the water bottles? Like any more than if you shot somebody with a gun, would you leave the gun? I don't think so. You wouldn't leave it behind. And would you keep calling the medical examiner for answers? So, yeah, Jessy knew that Lynn would take THC, take Visine, drink it, but she doesn't know how she died that day. Looked like a suicide with pills from a person who was unhappy. She kept calling the medical examiner, and the only reason medical examiner stopped talking to her, or their office, it wasn't because they said we don't want to talk to her anymore. It's because the detective put a hold on it and said, don't talk to anybody anymore. That's the reason that happened. And Gary Verdon was here in court. He told you, didn't he, that and that was a friend of Jenny's. Sure, it's a friend. But he saw Visine from the get-go. He saw it in her garbage cans on the occasions that he was at her house. And you know what? If he was going to lie to you.
Do you remember that liar on the stand? Yes, Jesse's mom's friend. Yeah, right. He saw it. No, he didn't.
He's under oath like everyone else. He's an honest person on the witness stand. I didn't detect anything from him that struck me as dishonest.
We did. We all did, right? We were all there together. We all did. Doesn't matter how much you paid him.
Objection.
If he's going to lie, why not go all the way and say, hey, I saw her drinking Visine. If you wanted to make up a story to help somebody, that's what you'd say. Now, Gary helped Lynn move. He was in the helpful friends circle. The state puts up the friends. They put those two charts of friends. Well, Gary goes in the Jessy and Jenny, actual helpful friends who did things like help her move her mother's things, run errands for her, visit her in the hospital. Those were that group of friends, her real friends, her real current friends. Sounds like Lynn varied friends from time to time. But remember when Gary was here and he talked about the phone call that he heard? He happened to be at Jenny Flowers' home, and Lynn's calling, and you heard testimony from people how Lynn would call, just talk, like to do that. And the phone was on speaker, and he could hear her talking for an hour or longer. And what was one of the things that he told you he heard her say? She had 3 ways she wanted to commit suicide. Also at the scene, another issue is the rigor mortis. It's undisputed. When did Lynn die? When did she actually die? If the deputy medical examiner had taken a temperature of her, we might have a closer idea, but what we have that we can use is the rigor mortis and the state of it. And it's undisputed and unrebutted. Rigor mortis starts in the jaw, the face, and starts to move down to the arms. From there, it goes over the rest of the body, and your trunk of your body gets rigor, moves to the large muscles of your legs, and they get rigor, but it hadn't gone to those spots on Lynn. It was at the beginning stages. The deputy medical examiner agreed with us that it completes within 6 to 8 hours. And she arrived at the scene at 6:10. Deputy medical examiner arrived at 6:10. She said it took her 30 minutes to look at the scene, to photograph, because a lot of the pictures that we've seen over the last 3 weeks were taken by the deputy medical examiner herself. She took them. So it took her time to look at the scene, look at the body, and so on. But her arrival was at 6:10. The 911 call was made right around 5 o'clock, a few minutes before. It took her a while. So rigor is increasing in that time. It's more than an hour, hour and a half even, from the time Jessy arrived at the home until...
Pause. Kathleen says, wait, I'm confused. What happened to the rigor? Such a good point. She used to say rigor. Remember? Wow.
She looks at the body. So it had not moved down to Lynn's trunk. It had not moved to her lower extremities. And so and that's consistent too, isn't it, with what Henry said about, Henry Spiller, about the drugs in her system and about how long had they been there. He said a couple hours. He used the phrase a couple hours. So what we can see by that, by the state of that testimony of how long the drugs are in her system and how far the rigor has progressed, that she's only dead a few hours. She died in the afternoon, not in the morning. I pointed out the Medical Legal Investigation of Death book by Spitz and Diaz, and Deputy Medical Examiner didn't dispute that what was in there would be authoritative. Lynn was being seen by a lot of physicians. The state has tried to suggest throughout this trial that there was nothing wrong with her, or basically nothing wrong with her, that she was not disabled, not in bad shape. That's what they have, that's how they've presented the case to you, but it's really not true. And anyway, does it really matter objectively what how somebody might perceive her? Does it more matter how Lynn saw herself? I think that's what really counts. If somebody is going to decide to exit, take their own life, then it's because of how they feel, right? It's not because of how you or me or anybody sees her medical history. It's how she feels about her life and her pain. And she was in pain. She saw herself as in a lot of pain. And we've got records from pain management that back in 2017, the pain interferes with sleep, with daily activities, and makes her feel frustrated. And at that time, she did the Owestry score and is 31 out of 50. And we introduced the Owestry disability score. And look at the things that a person rates themselves on. It's how intense the pain is, how intense it is to you, how your social life is. Do you have a good social life or not? How is your, sleeping, and how is your employment, and how is your friendships? And all of those things that you just fill it out, you let them know how you're feeling about yourself. And apparently, she saw when she filled out the answers. We don't know what they were, but however she filled them out, when it was graded, she came up with a 31. That's how Lynn saw her life, as a 31, which is almost completely disabled. Really, as how she saw herself. And the pain interferes with her activities of daily living. It says she's had pain for a long time. Look at that. Osteoarthritis in her lower lumbar spine since 1991. Numbness, weakness in her legs bilaterally. Pain aggravated by her ADLs, activities of daily living. And on her urine screen from September 26, 17th, it's appropriate for alprazolam, but inappropriate for lamazepam. It's not prescribed to her. We'll repeat it another visit. Again, she's not taking the pills the way she's supposed to. She's taking them not as prescribed. And again, they're stopping the opioids. We're going to stop the opioids. And you heard, didn't you, throughout this trial, the dangers of benzos and opioids. And we know that. We know that. We didn't probably even need to have people tell us about it, because we know it from what we hear of overdose deaths, the dangers of it. But here, she's got inappropriate pills in her urine screens. She was breaking her hydrocodone in half so she could make them last longer. Some things are giving her some relief, and some are not. But her She's got a lot of risks now, doesn't she? She's got risks of respiratory depression, mortality for taking opioids concurrently with the benzos. Her primary care physician and herself, this doctor, think it's important to stop one of the drugs. And again, we've got the osteoarthritis. The problems continue. And they got so bad, didn't they, that she's got so many drugs in her, and along with alcohol, that Lynn's been discharged from the practice, from her primary care's practice, because of non-compliance. And again, inappropriate for alcohol. The state at the beginning of the case, remember, asked their witness, Dr. B, whether there was any evidence in the record that Lynn had any problems with her eyes. No evidence. But it wasn't true. And I know it was painstaking as I was going through those, if we can remember back to day 1 or 2, as I was going through all those medical records with Dr. B, but there was a reason. Because it wasn't true, and I thought it was important that this jury, that you ladies and gentlemen see, that in fact, she'd been complaining about dry eyes and eye pain for a long time. Well, those statements weren't factual. Again, she was offered the referral to a pain psychologist. She declines it. She declines nutrition services. She declines physical therapy. And record after record, if you want to see it, you can ask, maybe possibly we can send those back for you to look at. But again, after again, she's encouraged to exercise, to quit smoking, and to not mix these pain pills. But it isn't just at Advanced Pain Management. It's also at Aurora, another facility where she was seen, and we can see that she struggled with anxiety. And they had a discussion, didn't they, with the side effects of taking benzos and opioids and the risk of morbidity. And so that was a discussion. And her doctor says due to her pain, all she does is sit around and smoke, sometimes 3 packs per day. I think there's 20 cigarettes in a pack. That's 60 cigarettes in a day. Day after day, that's all she's doing. Has chest tightness because of it. She continues to complain of GI issues and can eat only very little. So she says, eating very little, yet she's gained 30 pounds since December. I don't know how that happens if you're not eating. Again, she comes in for medication management. They told her, I'm not going to increase the benzodiazepines that you're taking. As the dose increases, your side effects increase, and your age increases the side effects. She's now in her 60s. I'm going to try her on Lexapro, half a tablet. She's got heart palpitations. And she has numerous risk factors. Heart disease, obesity, hyperlipidemia, for which she's refused statins, tobacco use, recommends stress test. Concerns, the doctor doesn't even list them because there's so many. Instead, she says she has complaints. Complaints are concerns which include numerous, in capital letters with an exclamation point. The woman was a complainer. And I'm not here to bash Lynn, but this is just the person we're dealing with here. She was complaining. And notes such as she has depression or agoraphobia, fear of going out, or she appears older than her age. And psych, she's very argumentative. She seems to be depressed. She seems to be, talks about having nothing since her parents died a few years ago. Another note, I told her it's unsafe to take alprazolam and Narco. High risk of cardiac death if she continues to take the Norco. I will not refill the alprazolam. I can't put my license at risk. That's how bad it had gotten. Can you imagine that in the record? Doctor's afraid of her own medical license. Lynn gets very mad at me and says I am the one who referred her to pain management. She wants the medication. She really needs to go see someone new for a therapist, but she won't do that. She's depressed. And again, the suggestion that there's no problems with her eyes is not true. December of 2017, she's at seeing Dr. Rogers, and there is a problem with eyes that is discussed. She uses artificial tears at least 4 times a day. So when the state starts their case and asks their witnesses if there's any indication that she's got eye problems, obviously the witness, Dr. B, didn't really take a close look at the records. It's just easy to say no, because they want it to be a death by tetrahydrozoline, right? That's the decision she made, and they're going to stick with it and not look at the entirety of the woman's medical history to see what's accurate or not. Here's another note. This is a new doctor, Abdullah. Now she's discharged from her previous primary care physician clinic due to breaching the contract, pain management contract. She tested positive for other substances. She weaned herself off of Oxy, supposedly. She's an only adopted child with no extended family. She lives in a condo she bought and has a couple friends who come visit. She also was at Pro Health, and the main records we know from Pro Health is from her hospital stay from September 15th through September 28th, 2018. That's a long time. Hospital does not keep you there for, well, that looks like 13 days. Unless you're not healthy. We know that from our personal experience. Now the state suggested, didn't they, that Jessy was lying when she said that she brought Lynn pills, lied about a camera, lied about pills, but it was true because it was in the record, which we'll come to in a minute. When she came to the hospital, she was not a person that really looked like she wanted to keep living, because she signed a do not resuscitate. She didn't want chest compression, no shock, no intubation. She's made that decision. And that's when she first arrives on September 15th. That's how she felt. There's the medications sent to the pharmacy for storage. The patient's medications sent to the pharmacy for storage. It was true. When the information was asked by the state of their own witnesses of whether or not there's anything in the record to suggest that Jessy brought medication to Lynn, and they said, no, 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 there it is. And who else told you but the neighbor? Remember when the neighbor came over or testified in court, Jean Tennell, and she also said that Lynn asked her to bring her medications, but she wouldn't do it because of the cameras. So if you don't even want to believe Jessy, certainly have no reason to discount what is said by the neighbor. Pro Health records, the diarrhea, the liquid stools, it's been going on for 4 years. This is not something recent, the suggestion that somehow Jessy's doing something recently that's causing this. 4 years. She did meet with palliative medicine, and they help patients and families dealing with serious, potentially life-limiting illnesses and to navigate their care. She seemed upset, refused to talk about doing what the GI was recommending, which is apparently a colonoscopy. But she's in the hospital for almost 2 weeks. There's something wrong with Lynn. She isn't in good health. She doesn't want to do what GI recommends. And frankly, if you remember, the testimony was that she would be released on the condition that she'd have a full-time caregiver. If not, the record said she was to go to a nursing home. Lynn didn't want to go to a nursing home. Lynn doesn't have full-time care.
Sorry, but the elephant in the room, the full-time care, was your client, Jessy. Which is probably why she said, don't worry, I've already got someone looking after me. Oh, I'm so glad you guys are here with me.
Another point. Remember, the witnesses were asked by the government, any indication that Lynn was needing a walker? No, none. Another thing that's not true. Because again, she began walking with a walker. It's in her medical record. It started before she came to the hospital, and there's a picture at the scene of the walker on the couch. She's got lots of past problems. Her medical history is significant. Don't let anyone tell you it wasn't. It was to her. So the state asked their witnesses after witness, remember any indication that Lynn was disabled. They started out their presentation by suggesting that the money she was getting from the federal government was for old age Social Security. That's what they were testifying to until we got them to agree that the money she was getting was for Social Security disability, not for old age Social Security. And remember, there's no indication, the witnesses said, that she was getting any free things from the government. There's no indication she was on food share or food stamps or Quest, nothing at all. But the certified records were admitted that show that Lynn was in fact getting, and we introduced these, that she was getting free food as early as 2015 or 2015. Sorry, I'm just drawing a blank on my date. I think it goes back earlier than that. For years. Even she was getting it for years. So we've got a woman that the federal government has determined is disabled to the point that they're going to give her Social Security disability, and the state's giving her food share, and it was 2015, I think, when she got it even before 2015. Now, we did hear the state brought in about the other friends. And I have no doubt that they care about Lynn in some way. But the person really who was there day after day, day after day, day after day after day after day to care for Lynn and to watch movies with her and to go shopping, and Lynn gave her money, no doubt. It was Jessy.
Exactly. Exactly. Connect the dots, everybody.
They brought in Kareem. I'll get to her in a second, but before her, what about Jim Kelleher? The state brings in Jim Kelleher, who wants to deliver a birthday present to her in September. Her birthday was in June. That's a very close friend, isn't it? Who's just thinking about giving a birthday present 3 months after your birthday. And we do know that as to Corrine Posa, who came in, she had a bit of a poor memory. And I can understand that after the passage of 5 years, our memories aren't as good as they were back when something happened. It's hard to remember precisely. It's hard to remember even 9 months later, 6 months later, sometimes even a week later. So I understand that 5 years have elapsed. But she denied, remember the discussion with her about the safety deposit box. And in the safety deposit box, was supposed to be $50,000 that Lynn had put in there. And we asked Ms. Posa, isn't it true that you told police back when you were interviewed originally about this, that Lynn had told you she had taken that $50,000 out of the safety deposit box? And she said no. But through the questioning of Detective Hoppy, he was able to tell you that actually back when Ms. Posa was interviewed 4 or 5 years ago, that she did in fact tell him that Lynn told her that Lynn had taken the money out of the safety deposit box. It wasn't in there anymore. She took her own $50,000 out of it. And the state wanted you to think that Jessy did that she took $50,000 cash out of it. It was taken out by Lynn who knows when. Also, on the stand, Ms. Posa says, oh, we're such good friends. Lynn and I were such good friends till the end, very good friends. But back 5 years ago, when she was interviewed, and this was verified by Detective Hoppy, when she was interviewed 5 years ago and asked how good a friend she was with Lynn, that time, right after Lynn died, she said, we used to be very good friends. Not so much the last couple of years. Not so much the last couple of years. This group of friends wasn't such good friends the last couple of years. Anthony. Well, Corrine said she last saw Lynn in February 2018. That's a lot of months for a very good friend. These are the cards that were brought into court, right? And submitted to the FBI lab, ultimately as known handwriting of Lynn Hernan. And Anthony Posa talked about these documents, and he compared these, and he also was talking about another document, wasn't he, in court, where he said, I know that document could not have been written by Lynn because two reasons. The two reasons were my mom's name, Corrine, is misspelled. And two, she used my mom's maiden name. Now, as to the second point, let's say if you've been friends with somebody for 30 years, we can all relate to people we've known since high school. We know them by their maiden names. People we've known for a long time, since they were single, we know them by their maiden names. We have them saved by their maiden names. I think of my high school friends by the maiden names. So there's nothing at all suspicious. In fact, it suggests that Lynn probably did write it, because what's the chance of Jessy, if that's the suggestion, Jessy knowing what Corrine Posa's maiden name was? But the other point he said was that she couldn't spell, she would never misspell my mom's first name. But then they brought in the cards, and her name is spelled differently in almost every card. If you look, Corrine, Corrine with an E, there's an I in that one. I mean, there's 1, 2, 3, 4 cards, and every one of them has Corrine spelled differently. Though Lynn couldn't spell first names, apparently. But to suggest, as Anthony did, that the document is not written by Lynn because Corrine is misspelled is contrary to what we know are known documents. Because suppose the family brought these in and showed them. Of course, they also said, Corrine also said, did she not, that Lynn was always writing things at home. She always had her pad. She was writing wills. She was writing documents. That was something Lynn was known for. And she said there would be documents everywhere, here and there, all around the place. So that's something that Lynn did. That was Lynn. Writing new wills, writing obituaries, writing cards, writing letters, writing notes. That was Lynn. That's something she did, and most likely did even when she was in the hospital sitting there for almost 2 weeks. when Jean was brought in to court and said that, denied that she had said Lynn was suicidal, but we established it through the detectives that she was. Remember when the medical examiner was here and we introduced her own data, the medical examiner's own data, to show, does it not, that people do commit suicide. This is for Waukesha County. This were the years that she provided information on. And we have plenty of people in the age range of the 41 to 65 and above. 2020, there's 37 people in that two higher age ranges that committed suicide. And how do people commit suicide? You can see all the ways in Waukesha County that it's happened, and it's sad. We're sad that people ever feel that to that point that they that's what they want to do. But people do it. People do choose to exit. And we have any number of people that have ingestion type of deaths, suicidal deaths, where you ingest some substance. And here, when we ask for the breakdown of what types of products or pills that people are taking to kill themselves, we got this breakdown. And remember, Dr. B went through it and she marked how many were actually overdoses from benzos and opioids. Very dangerous drugs. Lynn was thinking about her death. She wrote her own obituary. She'd been thinking about her death since at least 2016, because that's when this particular document appears to have been written and notarized by one of the bankers at BMO, who came in here and indicated that's her seal, that's her signature. She's the one who notarized this document. Misspelled Jessy's last name. She can't spell names. But Lynn wrote that. Jessy wrote that. She's not going to misspell her own name. Make no mistake about it, Dr. B is called this cause of death tetrahydrozoline poisoning, that and that alone. That's what she says the cause of death is. She's never had a tetrahydrozoline death. She has no experience with that at all. Zero. This is the inventory that was taken of all the pills at Lynn's home and what was prescribed and what remained. 0, 0, 0, 0, 0, 0, 1, 0. Lynn took a boatload of drugs. When the first test was requested from NMS Labs and it came back, it didn't even check for baclofen. How is it possible that you really paid attention, doctor, to what was at the home? There's bottles of baclofen here, and you don't ask for a baclofen test to be done. It's a deadly drug. Henry Spiller said to you, that's the bad boy. In this case, that was the bad boy. So she's got it. Yeah, she ran a lot of tests because, oops, I forgot to check for baclofen. Need to run it again. What were the drugs in her? Baclofen, cyclobenzapine, hydrocodone, alprazolam, nifedipine. Not fatal levels. The state says these therapeutic levels. Therapeutic levels? No.
She was well known to like drugs and alcohol. That never changed. Lynn grew up that way, and she stayed that way. Maybe the pills changed, or the alcohol changed, or the drug of choice, but that's what she did. So it's just, it's so frustrating sometimes. Just thinking of like how she was.
So I'll tell you this, she didn't overdose on any kind of prescription medication.
Okay.
Everything was at therapeutic level.
Therapeutic level. No. Dr. B testified that Visine, which is the product we know with tetrahydrozoline in it, testified about it. We know it's been on the market since 1959. We didn't hear about any reported deaths. She says it's outlawed in France. That's not true. It's not outlawed in France. It's not approved. No one sought approval. It's not outlawed. It's being careful with our words, not trying to mislead you, ladies and gentlemen, of the jury in this case. There was no evidence presented.
No, that's literally all you do. Literally. Victim blame and shame and mislead and lie.
That any company was denied approval of tetrahydrozoline or Visine in France. It's misleading, as was Dr. Kasinko's abstract. Misleading. She put statistics on there. Statistical trickery. Well, maybe that's a little harsh on her. Maybe that might hurt a little bit to hear that. But that's how Henry described it. He is so experienced in this area of toxicology. He's peer reviewed.
He is so experienced that he can poke people with a stick, just to check that they're dead. He can even reenact, sexual assault victims, how they feel when they wake up from being, having a spiked drink. Yeah, he's really professional.
Review toxicology articles for other people that want to print them and have them published. He's the peer reviewer, one of them, not of his own, of course, and it wouldn't pass muster. And I understand that she's a younger scientist. I understand that she wants to find a novel subject to write about. I understand wanting to be recognized. But this is only an abstract. It's not even a written article, much less submitted for peer review, much less next step, go to be published in any kind of literature. Henry, on the other hand, has written and published at the Nobel level. I mean, we're talking over 200. A 44-page curriculum vitae, CV. These were the positive findings that came through, and look at what she has in her system. It's just incredible to see the number of drugs and the quantities of the drugs. And maybe one alone, fine. But the combination, deadly. Dr. Thomas said it was a polydrug overdose. Where does tetrahydrozoline rate in the dangerousness of the drugs, according to Henry Spiller, world-renowned expert in toxicology? At the bottom of the list. At the bottom of the list. Remember also Dr. Kasinko bringing in an article that in her rebuttal, she came back up for like a last rebuttal. She brings in some article that is from somebody she met at a conference. It's been cited twice. In other words, no one's citing that article. It's cited twice. It's not well received.
Okay, so you're saying that Dr. Kasinko, irrelevant. Ooh, Spiller is not even a doctor poking dead people with a stick. He is so relevant and amazing because he's got a 44-page CV. Talks a lot of bullcuck.
In the toxicology community because it's not being cited. Now, Henry Spiller is able to, with his decades of experience at working at national poison control centers, where he's doing real-time work with people in hospitals who are in for overdoses. And he is dealing with the doctors and the nurses and the hospitalists and the emergency room people, and he's trying to calculate what's going on and what's in their system. Remember, a girl says, I took 20 Tylenol, and he says, no way, didn't take 20. I know based upon the levels I'm seeing, it's 30 or 40, whatever the number was. He knows that. He does that. It's what he does to save people's lives. And he follows the patients, doesn't he? From the minute he gets the call from a hospital that somebody's on an overdose through their discharge or their death. He knows how to calculate how many pills. Nobody else knows how to do that that was in this trial. And he calculated that Lynn has 33 to 42 tablets. And it's higher than it was originally because other drugs were found. Because remember, there were pills in her belly, right, that were never tested. But he did the calculation, 33 to 42 pills. That is a boatload of pills, consistent with this boatload of pills, bottles, mostly empty, not all, found at the scene. And nobody's shoving 33 to 42 pills down somebody's throat. No way. Remember.
Yes way, if you crush them. That boatload. She said boatload about 7 times. Boatload of stuff, boatload of pills. Okay, and she's like, no way. No way can someone shove that down someone's throat. Oh, okay, what if they crush it and mix it into pudding or water or whatever it is? So many other possibilities. This is, I wouldn't be able to make it without you guys.
Lynn was a savvy pill taker. She'd been taking pills and all sorts of pills for a long time. No one's going to trick her on her pills. Lynn knows what she's doing. She's been taking them for years. And there's no indication in the record that anything was forced, because I specifically asked if there's any sign of injury to a mouth, to a throat, a trachea, anything to suggest that there's any kind of forced ingestion, and there isn't. There is not. She took them herself because she wanted to. And as to those other cases that were cited by Dr. Kasinko, for example, Henry Spiller actually calculated the amount of tetrahydrozoline that was in that child at peak. 115 ng per milliliter. Now there's a scarcity of cases. You think that we should be able to come in here and show you case after case after case of tetrahydrozoline and what levels should be, but there aren't. If they were out there, we would have them here for you to see. But there is that case where he's able to do the calculation. 115, Lynn was 160. 115 had a little bit of problems, a little bit of respiratory depression, used a little mask of oxygen on the child, rapid improvement. That's what 115 ng per ml does to a little child. And he made a point to let you all know that children are not little adults. The effects on a child of any kind of drug are going to be much higher, stronger than that on an adult. Yeah, the five pills. 5 pills found in Lynn that the medical examiner never tested. And in fact didn't know what they were, never bothered to figure out what they were until we met with her and pointed out the number 30 on one of them, and couldn't that be nifedipine? And between that date and when she came into court, she agreed, she looked it up to see if we were right, which we were. She said, you were right. None of this was taken into consideration by her at all. Never tested them. What kind of medical examiner, when you're talking about a poisoning, so fixated on the THC? Why did she fixate on it? She'd never seen it before. I agree. Probably, if she says that, it's probably true. It's Sherry Kasinko from NMS Labs who was all excited, wasn't she, about, at that time, about this high level of THC, because she's wanting to do this article. She's got an abstract, she's getting her lab automatically test for THC, and now she's got this case with a high level. She wants to be recognized, she wants to cite it, so she gives a suggestion to Dr. B that this is fatal. This is what killed her. Because what other evidence is there of it? There's not. It's not true. There's a lot of drugs in her system. Dr. Thomas told you that. Mr. Spiller told you that. You can see the charts for yourself. It is just an incredible number of pills. And Lynn wasn't healthy. Dr. Thomas was careful to tell all of you about the other problems with Lynn, like her fatty liver disease, which shows the alcoholism, the stenosis that she would have thought if there wasn't anything with drugs, that there would have been a heart issue that might have killed her. Her obesity, she's 251 pounds at death. How did she gain? You know, from earlier records, we see 50, 100 pounds.
I wonder how, when one is battling thyroid cancer and there's so much medication for all the pain, the actual back pain, and then like possibly being poisoned with Visine, organ swelling, you know, just organs not working properly anymore. You know what I mean? Oh, this woman and her fat shaming, I can't even. Yes, in capital city cases, the only thing Dr. Spiller did in this court was give the court reporter the flu.
This is incredible weight gain. It's type 2 diabetic, the pulmonary disease, the interstitial myocarditis, the hypertension. The woman had a lot of health problems. And Jim Berg was in court to talk about her finances too. He said that she was broke. She knew she was broke, tying into financial things. This wasn't news to her. But before I leave on the medical part of it, remember Henry Spiller said that he did write an article about tetrahydrozoline and its effect in sexual assaults. And he said he wrote it and did the research on it because he wanted the FBI to adopt this as one of the standard tests that they use when rape kits are done. And of course, when the FBI makes recommendations, you don't have a city or a state is free to reject or accept them. But his goal was to get the FBI to recognize that THC, to make the testing for THC a part of the recommended national protocol, I think is what he said, when they're testing blood or urine. And that's probably, isn't it, why NMS Labs ultimately put the testing for tetrahydrozoline in their regular testing regimen, because they get all blood or urine to test in all sorts of cases. People use the lab not just because somebody died, but for any reason, including you could send urine for a rape test. And so they accepted that recommendation, it seems, and put that as part of their regular testing. So when it comes to first-degree intentional homicide, the state has not proven it. They have the burden to prove it beyond a reasonable doubt. They didn't do that. They failed. Such a serious charge. Defendants aren't required to prove their innocence. The law presumes every person charged with a commission of an offense to be innocent. The burden of establishing every fact is on the state. Ladies and gentlemen, if you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so. You must do so. Return a verdict of not guilty. And as to the homicide, that's exactly what we have here, an absolutely reasonable hypothesis of the defendant's innocence. And you must return a verdict of not guilty if you agree with that. There are other words in jury instructions, such as you should. But here, this one is must. It's must. Of course, the last part of the instruction, and what no doubt the state will indicate to you when they get back up here, I don't get a second turn. They'll say, it's your duty to give the defendant the benefit of every reasonable doubt, but you're not to search for doubt, you're to search for the truth. But by their own admission, all we have here is circumstantial evidence. There is really, that's all it is. It's a circumstantial evidence case. I don't know, it's not easy to search when you're missing so much information, like testing of pills and saving of evidence at a scene. And I did, and I hope you can see my chart, because I think it's important to look at how, what does that even mean, reasonable doubt or proof beyond a reasonable doubt? It's such a legal term. It's hard to understand it. But you can look at this chart and kind of get an idea. If there's no trace of evidence, of course, that would be not guilty. But even if there's any evidence at all, a scintilla of evidence, that would require a not guilty. If you have a reasonable suspicion, which should be based on specific or particular facts or reasons, it's not based on a hunch or a guess, so it's more than a hunch or a guess. Call that a reasonable suspicion, not guilty. What about if you got probable cause? You hear that all the time, even if you're watching TV. We got probable cause, we're going to get a warrant, or probable cause for this or that. Reasonable and trustworthy information that a particular person has committed a particular crime. What if we have that? If you think that there's that here, that's a not guilty. Well, let's go even higher on the chart and think about, what if we've got the greater weight or amount of evidence? In other words, there's a greater weight of the state's evidence compared to the defense evidence. If you felt that, which I don't, based upon Dr. Thomas and Henry Spiller, but if you felt it, it still requires a not guilty, because that's only a preponderance of the evidence. That is inadequate to convict. Even if you have a firm belief that the allegations are true, in other words, clear and convincing evidence, you must vote not guilty. That requires not guilty. And if there's any reasonable doubt, it's not guilty. Only if the state presented evidence that went on that ladder, those stairs, all the way up here, would you be able to vote guilty? And I submit that as to the first degree, intentional homicide, the intentional taking of Lynn Hernan's life, that they have not proven their case. I do want to talk to you about the financial things. So, the state suggests that Jessy was taking all this money from Lynn. Actually, Lynn and Jessy were close, and Lynn gave Jessy money all the time because she wanted to. And Lynn spent a lot of money before Jessy was even on the scene. We took the total account balances, and you can look at it if you want to dig through the financial records. We've added things up, and you can see that in 2014 she started with $346,000, and by January 15 of 2015 she's down to $305,000, and by January of 2016 we have her down to $272,000. And the first check that was written to Jessy, ladies and gentlemen, was in July of 2016. And this this continues on for the rest of the accounting. But remember, the first checks to Jessy are in July of 2016, and FBI, who we brought in here, again, the state did not bring in the FBI. They didn't want you to hear from the FBI. The checks written to Jessy, she rated them as a common source. Support for common source. Now, I know that this chart is not the easiest chart to understand. I had to have it hammered in my head again and again. So, of course, if they never say they're certain. Apparently, the FBI doesn't do that. But we've got inconclusive in the middle. We're not sure. As we move to the right, it's more likely that the person wrote it, and as it moved to the left, it's more likely the person didn't write it. That's really how this goes. So all the checks that were written to Jessy, the name, Jessy Kurczewski, not always spelled correctly, and the numerals were support for common source for Lynn. That Lynn likely wrote the Jessy's name and the amounts. As to the signature, the Lynn Hernan signature, because of the lack of clarity in documents that she had at her disposal, she was inconclusive. That isn't a support for a different source. It's inconclusive. And I think there was a suggestion during this trial, as I recall, somebody suggesting, well, if Lynn had duplicate checks, wouldn't Jessy be able to duplicate her signature from the duplicate check? Well, first of all, that's a if. There's nothing in this record that Lynn had duplicate checks. So that would be a guess. We're not here for guessing. If Lynn had duplicate checks, bring in somebody from the bank, from the deluxe check ordering company. The state should do that, right? And say that Lynn had duplicate checks. There's nothing in this record that she had. But second point, we know, don't we, from our duplicate checks that the signature is blacked out. They've done that for years on duplicate checks just for the purpose that if somebody steals your checkbook or you misplace it, you lose it, that people aren't going to see your signature. So that's just ridiculous. Now we have known writing of Lynn. This was known writing of Lynn. Lynn liked to spend money. She liked to give money away. She liked to spend beyond her means. She liked to give away beyond her means. That's what she did. And giving money to Jessy made her happy. Jessy was like her daughter. Jessy was the person who was there all the time, and Jessy probably gave her a hard luck story. I need money for this and money for that, but Lynn was happy to give it to her. The crime requires that it be without her consent. There's no evidence here that Lynn didn't consent. Lynn, in fact, gave the money willingly to Jessy. But she liked to spend money, and she liked to give it away. As I told you, check item numbers 47 through 56 and 58 through 83. Those were support for the writing being of Lynn's. She wrote the body of those checks. And the two in between that, I should point out, because you might be wondering, well, where's 50 or 67? I think this 57. They were confirmed as Lynn's signature. I'll look at how her spending dramatically increased. So here we've got Lynn going to the hospital. She got $19,000. She has a discussion on September 21st with palliative care and spend. Once she knows that she has to either go in a nursing home, which she doesn't want to do, she's made a decision. And it's spent and spending. And that's when the ATM withdrawals began. And Lynn liked to have cash. Of course, she sent Jessy to do things for her. Lynn's discharged from the hospital and she's down quite a bit of money, and is all after her discussion with hospital people about the palliative care, having to go into a nursing home or having full-time care at her home. Withdrawal, withdrawal, withdrawal. Okay, now think about the two loans you heard about in this trial. You heard that Lynn applied for a loan first with her primary bank, which is BMO Harris. And there, if you looked at the documents carefully, she did exaggerate her income. It was exaggerated about 50%. She did note on those applications exactly what she had in the bank, and the application was done face to face. In other words, she was there at the bank doing the application, and she put down how much money she had in her bank account, and it was under $20,000. The suggestion has been made that Lynn was being taken advantage of and had no idea of her finances. False. She knew. She put it on her loan application. Now that was denied. So by increasing her income by 50%, she doesn't get the loan. So they together decide to make the application for Goldman Sachs. Goldman Sachs, they put up its income of $100,000. It's obviously poor underwriting, never looked into anything, but they accepted the documents and they gave the loan, they approved it. And on the day of the disbursement, the key thing is Jessy added Lynn to her Wells Fargo account. She was added. And as to switching the names and adding her to the account, that was done in person too. We brought in the man that did that form with Lynn and Jessy at the bank, and he told you, you'd be there in person in front of him with identification to prove who they are. Not only that, but he's so careful to make sure that people are not being taken advantage of, that both the customer and the, both people, both customers before him are not being taken advantage of, that are in a good mental state, that they know what they're doing, and that in fact, we heard that all the banks do that. That's part of protocol. They just make sure that they don't see anything, that somebody isn't nudging somebody or signing for them or whispering and telling them what to do. So they did go for a loan, and there were obviously falsities told about Lynn's income of $100,000, but she wanted the money because by the time that February of 2018 rolled around, she didn't have much money in the bank. She just applied for the loan at BMO, and she had listed her assets at under $20,000. So Lynn was well aware in February 2018 that she only had $20,000. As to the theft from Lynn during her life, the state has failed to prove it. The record before us shows that Lynn gave Jessy the money willingly. She had no one else to give her money to. You can you might question it if somebody has heirs that are alive, like children, grandchildren, that you might want to leave your money to, but Lynn did not. She wanted Jessy to have it. She knows she's going out. She's giving it to Jessy. It is a lot of money. It's a tremendous amount of money. But just because it's a lot of money doesn't mean that Lynn didn't approve of it. And in fact, the evidence suggests she did. Jessy was the person that was there. No one else really knew Jessy. I knew Lynn like Jessy. She knew her. They're the ones that spent time every day, 12 twice a day together. And Lynn made a decision. She made a decision that she was going to exit. And she did that on October 3rd, once Jessy had left the home. We know it was then because of how long the body was deceased. The body was not dead in the morning. The rigor would have spread. That's just false. She put on her father's dog tags. That's a sentimental thing to do. That's when you're thinking about going to another place to be with your loved ones. I'm going to join my father, join your father, join her father, the person that she loved so much. She put on his dog tags.
And I don't mean that in a mean way, I mean it truthfully. She did a lot for me. So the fact of her being dead would do what for me?
Well, the debt's kind of coming up to overtake the assets. She has more credit debt than she has money.
Yeah, that's what I'm saying.
So the money's running out.
Yeah. So, but I don't get what you mean by that. I mean, yeah, they were. I don't understand what you're saying.
The fact is she paid you $200,000 over the last 2 years.
Mm-hmm.
You're the prime. You are handling the money. You are on the sign or on the accounts. Yeah. You are running the show.
Yeah.
You are handling the credit card stuff.
Mm-hmm.
You know what's going on financially with her.
Mm-hmm.
The money is going to be gone here shortly.
So I would kill her because of that?
People do weird things.
Why would I kill her for money?
I mean, it's
my family.
I tend to think that you didn't. When you say kill her, I don't think you killed her. I think she was sick, and she didn't want to. She was done, and she wanted to finish her life, and she needed help.
And even if you think, as the detective did, that that's what Jessy did, that is not a first-degree intentional homicide, which is what is charged here. Look at the elements of the crime. That is not it. Even the detective thought it. As to count 2, the state has not proven beyond a reasonable doubt that Lynn did not consent to giving Jessy.
I'm just pausing quickly. When I started my stream, it was obviously after the initial, when the judge was talking to the attorneys. The state said that they need about 90 minutes. But the judge said because this trial has so much evidence, so much information, she's not setting a time limit on the closing argument. So the state said they think theirs would be about 90 minutes, and that was it. The defense did not indicate how long they need. So I don't know how long it's going to be.
Jessy that money. And in fact, she did consent. And remember, if you can reconcile the evidence on count 2, the theft while Lynn was alive, with any reasonable hypothesis consistent with Jessy's innocence, you must do so. You must do so and return a verdict of not guilty. As to count 3, which is the theft from the estate, really the only comment I would make to you, ladies and gentlemen, as you heard during the case, the estate's not even closed. The estate is still open. When you go to the jury room and you deliberate and you look at all this evidence, and if you want to see something, send a note. We'll send it if we can. I ask you to return verdicts of not guilty. The state has not proven their case. The only true and correct verdicts are not guilty. And thank you.
Thank you. While you take those down, we'll just stand for a little bit. The state does have an opportunity to offer.
Hey, so my little trick worked there. I just thought maybe it worked. 1.25 speed, let's just hurry that along. And then it's over. Okay, cool.
A brief rebuttal, so we'll hear from that and then the final instructions. Just a note to all the people in the gallery, no one should have food, gum, or drinks. So if you have any of those, please step out and get rid of them. Thank you.
The guy, he's like, okay, I'm stepping out. I have my gum. And my energy drink. That was great, right? As in, that it's finished. That's what was great. Okay. I'm just gonna speed this along. Let's see what we missed. We're teleporting a little bit through the fluff.
All right, thank you. Have a seat. Attorney Nickolie, when you're ready.
Thank you, Judge.
Here we go. Here we go.
Ladies and gentlemen, because we have the burden of proof, I get to address you one more time. And the video you were left with was Jessy Kurczewski asking the detectives, why in the world would I have any reason to kill Lynn Hernan if all of her money is gone? I submit to you there was 87,000 reasons to do that. Because that's the amount of theft that Ms. Kurczewski has taken from the estate in this case. This is supposed to be a search for the truth. And what has happened is that it has become a full-blown attack on Lynn Hernan. I want you to think about some of the things that you've heard said about this woman. And then ask yourself, why does that matter? She's an alcoholic. She's an angry drunk. There's bottles of alcohol at the house. The intent is to mislead you. Lynn Hernan had no ethanol on board at the time of her death. Lynn Hernan was not a bad person. She was a complainer. She smoked 60 cigarettes a day. She needs to exercise. She was 251 pounds at death and bad at spelling. Why do those things matter to you? Why were those things presented to you over and over and over again in this case? I submit to you, the intent was to mislead you. The intent was to shift your focus from the truth, which is what you are to be searching for. If Lynn Hernan taking her own life was such a reasonable hypothesis, consistent with the defendant's innocence, then why did she have to lie about it? I submit to you, ladies and gentlemen, that the reason that everyone at the scene thought this was a suicide is because that was exactly Ms. Kurczewski's intent that day. And it worked for a period of time until the toxicology came back. Is it really so surprising that detectives on that scene weren't taking empty water bottles with them? Do you think maybe what was collected would have changed had a witness come up to them and said, she's been drinking Visine for months. She's trying to kill herself. The intent was to mislead. Certain pills that she couldn't swallow, she had to crush them. That is nowhere in the medical records. Ms. Kurczewski told Detective Hoppy that she brought meds into the hospital and told staff, I gave all these meds to Lynn, she's suicidal, and that staff took those away and put a camera in there because of that. That's a lie. That is nowhere in the medical records. You were asked if Dr. Bedritsky thought this scene was staged. Why didn't she do something right away the next day at autopsy? Oh my gosh, the scene was staged. I have to do something. She did. She collected all that powder. The first time she'd ever done that, she collected it and sent it to be tested. You were asked why would Ms. Kurczewski leave these expensive bracelets behind? You know who got those, though, because we showed you. Very quickly after, Ms. Kurczewski goes and pawns those items, lying to the pawn store, saying she's owned them for months and months. and takes the cash that they're worth. Oh, she got those bracelets. Was there $50,000 in a safety deposit box or at Lynn's house? The thing we know about that is that that money was supposed to go to Anthony, and he sure didn't get it. I submit to you, ladies and gentlemen, when you consider the mapping evidence in this case, and you see Ms. Kurczewski go back to Lynn Hernan's house that night on October 3rd, after everyone's gone, and the next day on October 4th, accessing that lockbox, consider that timeline. I have no doubt Ms. Kurczewski knew that cash was gone when she talked about the lockbox with Detective Hoppy, but that's not why she brought it up. She brought it up because she alleged there's all kind of exculpatory stuff in there that Lynn saved. I'm suicidal, and recordings that I'm suicidal, it's all in there. She knew there wasn't anything in that lockbox, and that's why it's significant for you to consider. You've been now told that Gary Verdon is this really honest, upstanding guy who listened to a woman go on and on for an hour and a half about killing herself and didn't do a thing. A man who told you with a straight face that he remembered a bottle of eye drops in Lynn Hernan's garbage can because he had never seen them at anyone else's house in their garbage. That makes absolutely no sense, and you need to weigh his credibility when you consider whether anything he said is correct. The same that you have to consider evidence as it was admitted into the record and not what Attorney Kuchler wants it to be. Gene Tannell did not tell you Lynn Hernan was suicidal. No detective told you that. Attorney Kuchler's comments are not evidence. Henry Spiller did not convince Dr. Kasinko to start testing for tetrahydrozoline at the lab. The spending that you were just shown in the blue charts absolutely matches what we proved to you in this case, that it changes drastically in 2016. Attorney Kuchler says, we didn't want you to hear from the FBI. What the FBI was able to tell you in this case was that someone could have written something, but also maybe not. That's the extent. Attorney Kuchler told you, well, the FBI never makes conclusions. Well, they do. They do. It was on the right side of the spectrum, and it's called source identification. I want you to think back to evidence that you've seen in this case of the one person who is very acutely aware of creating fraudulent documents that are very convincing. And I want you to recall that Ms. Kurczewski told a roommate that she messed with that handwriting process anyway. So you're right. The state didn't think that that was important for you to hear in this case. Dr. Bedritsky is not going to make an important determination like the cause of death in 14 hours. Dr. Thomas did. Dr. Thomas, someone the defendant hired and paid to be here and tell you that. But she didn't tell you it was a suicide either. Dr. Thomas certainly didn't have the benefit of all the interviews that you've seen. Dr. Kasinko testified and showed you that abstract because 3 weeks ago you were told by that team that you can't die from tetrahydrozoline. And that is not true. That is the value that Dr. Kasinko has to this case. She has her own data and her own lab to know that that claim is irresponsible and not true. Who didn't take a look at medical records in this case before offering a pretty serious accusation? Mr. Spiller, the graduate of a now defunct university with no doctorate degree, who told you that it's real important when you're making calculations to know about genetic or disease issues that would affect metabolism, had no idea that there was any issues with Ms. Hernan's liver. Dr. Thomas said, oh yeah, she did, and that would be real important to know. Nonetheless, he got up there and told you handfuls of pills that Lynn Hernan had. Why? Why was that information presented to you? Because I trust that you all have comprehended by this point that the things in someone's system affecting them at any given time are the levels in the blood. And that undigested, unmetabolized things in someone's stomach has no bearing. That's why Mr. Spiller said that medical examiners around the nation are not calling him and asking him to do these calculations for them. They know what affected someone because they have the tox in the blood. So I again ask you to consider, why were you presented that information? I hope it doesn't mislead you. I hope it doesn't shift your focus. Because, ladies and gentlemen, dry eyes didn't kill Lynn Hernan, back pain didn't kill Lynn Hernan. And I will mention this very briefly, because the palliative care discussion during this case has taken up more of your time than the actual consult did in the hospital, which was 30 minutes. Look at that record. It does not say what Attorney Kuchler wants you to think it says. Attorney Kuchler got up here and...
I'm going to object to the constant reference to Attorney Kuchler.
Overruled. These are closing arguments.
Attorney Kuchler got up here and showed you a picture from Lynn Hernan's body of dog tags and told you that those mean something and that's why she put those on, so she'd have them on when she got found. But no pants or underwear? Think about that for a second. You're making this decision. You know that someone's going to find you, and you're not going to put pants and underwear on? That makes zero sense. Detective Hoppy told Ms. Kurczewski during the interview that, I think you found the perfect victim. She had no family. You isolated her, and she had money. This group of friends who supported Lynn and loved her, that didn't see her when Ms. Kurczewski entered the picture as often. Why was that? Why didn't Lynn see the Anthonys and the Coreens? Absolutely, she wasn't feeling good, and no one could figure it out. But ultimately, ladies and gentlemen, to believe that this was a suicide, you would have to believe that by the most cosmic intervention in the entire world, it happened at the exact point in time when Ms. Kurczewski maximized the amount of money that she made on this whole ordeal. I want you to think critically, and I believe once you have, you'll return guilty verdicts in this case. Thank you.
That was so good.
Thank you. I need to see the attorneys just for a moment. You all can stand.
Yay. Attorney time. Let's see what happens. Ooh, okay. So it's silent. It's a silent portion. I like that the jury's smiling, but probably telling them, what the hell was that? You know, Attorney Kuchler. I object. They're saying my name too much. Okay, so there we go. Closing arguments. Ooh, jury instructions. I've already given them. So, right? They gave closing arguments instructions. Jury instruction. They're going to deliberate. I wonder how long this will take. Sure. Okay, they're back. We don't hear sidebar ever. Let's see, we are 2 minutes behind. Yeah, we had 1.25 speed to catch up. Oh.
This case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 6 forms of verdict will be submitted to you concerning the charges against the defendant, Jessy Kurczewski. Count 1. One reading, we the jury find the defendant, Jessy Kurczewski, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Jessy Kurczewski, guilty of first-degree intentional homicide as charged in count 1 of the information. Count 2. We, the jury, find the defendant, Jessy Kurczewski, not guilty of intentional transfer of movable property having a value that exceeds $100,000 as charged in count 2 of the information. Hold on.
Ooh, she's looking nervous now.
Every now and again, we find a little mistake. So, as our verdict forms read a little different. So, I'm going to do that as to count 2. One reading, the jury find the defendant, Jessy Kurczewski, not guilty of theft of movable property having a value that exceeds $100,000 as charged in count 2 of the information. Another reading, we, the jury, find the defendant, Jessy Kurczewski, guilty of theft of movable property having a value that exceeds $100,000 as charged in count 2 of the information. If you find the defendant guilty, answer the following question, yes or no. Was the property stolen more than $100,000? Count 3. One reading, we, the jury, find the defendant, Jessy Kurczewski.
No, we don't want buffering now. Sorry.
Every now and again, we find a little mistake. So, as our verdict forms read a little different. So, I'm going to do that as to count 2. One reading, the jury find the defendant, Jessy Kurczewski, not guilty of theft of movable property having a value that exceeds $100,000 as charged in count 2 of the information. Another reading, we, the jury, find the defendant, Jessy Kurczewski, guilty of theft of movable property having a value that exceeds $100,000 as charged in count 2 of the information. If you find the defendant guilty, answer the following question, yes or no. Was the property stolen more than $100,000? Count 3. One reading, we, the jury, find the defendant, Jessy Kurczewski, not guilty of theft of movable property having a value greater than $10,000 but does not exceed $100,000 as charged in count 3 of the information. Another reading, we, the jury, find the defendant, Jessy Kurczewski, guilty of theft of movable property having a value greater than $10,000 but does not exceed $100,000 as charged in count 3 of the information. If you find the defendant guilty, answer the following question, yes or no. Was the property stolen more than $10,000? It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached, of course, as to each count. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Madam Clerk, at this time, please swear in the officer.
Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I will.
All right, for the record, both of our jury bailiffs were sworn. All right, as you can see, I pulled out the tumbler. It has the information for each juror. I will give it a good spin. All right. First juror will be an alternate and not initially or until perhaps not ever deliberate as juror number 28. All right, the second juror, number 13. And the third, number 19. Now, we will have you in a separate jury room where you will wait. You will not be able to discuss the case amongst yourselves, those who are the alternates. I'm not going to take away your electronics or anything like that. The same admonition that I've given you throughout this case remains. You may not discuss this case with anyone. You can't do any research. Don't review any newspaper reports or news reports. And if something were to happen to one of the other jurors during deliberations, then I would obviously have a conference with the attorneys and we'd discuss how to proceed next. I know that can be a little bit of a letdown, and we so appreciate all your time and attention here. You'll all be excused. I know that lunch was ordered, and Jen and Ken will figure out all of that. But all rise for the jury, please. my new pages in here. That's the good news. Very good, Jen.
Okay.
That's fine. All right. For the record, Madam Reporter, it's 12:21. And for your record, Madam Clerk, just be seated for one moment. I do want to put that sidebar on the record. I informed the attorneys at sidebar. There was just a little bit of a snafu. Normally, I have the CCAP application, do the randomized listing. Unfortunately, when that was done, we had a little bit, I guess, lost in translation about number 28, and believe it or not, it will not let you redo it. And so we brought the tumbler out, and then by agreement of the parties, we agreed that 28 would be the first number that I read, and that is what I did. Anything either side wants to add to that sidebar from the state?
No, thank you.
From the defense?
No, thank you.
All right, as you know, it's we remain open while the jury is deliberating. For the attorneys, if you choose to leave, just please, I think you've already given Madam Clerk the best contact number. My intent would be to let the jury deliberate as long today as they are comfortable doing, and if that does not result in a verdict, send them home, bring them back. Obviously, we'll cross that bridge if and when, but if they do receive or when they reach verdicts, then I will give probably about a half an hour to 45 minutes to make sure everyone can assemble back here. If there's a need for me to go a little bit longer than that, for whatever reason, if there's a family member that's a little bit farther away, just let me know and we'll work on that, okay? Otherwise, we are in recess. Thank you, everyone.
Okay, is that it for the day? I'm just quickly setting up the next stream, which will be the verdict. Just so that this one will lead you there. Wow, okay. The poll is still there, Barbara. It's still there. The poll is up. So you guys, I said, how long do you think they will deliberate for? 63% said 1 to 4 hours. 27% said 4 to 10 hours. 5% said 10 to 24 hours. And 4% said 24 to 72 hours. Okay, so now we're on verdict watch. So what I've done is I created another stream. Let's just take this off because it doesn't really help looking at the ceiling, does it now? And that stream ended too. Okay, so they actually ended that stream as well. Yes, okay. Not that Mickey says, gee, how long do you think they'll deliberate? Because there's 3 charges, I feel like it could take a little longer. You know what I mean? It could be, I'm just guessing, obviously, as you know. I think it could take a little longer than by just today, but it depends. Maybe by tonight, which obviously is tonight in Waukesha time. For me, it'll be like 4 in the morning or 6 in the morning, something like that. So you know I'm going to be sleeping with one eye open tonight, waiting for this verdict. Now, what I want to ask is, if you see, oh my word, the verdict has been reached. If you see it on Facebook or Twitter, which is called X now, or if you see it on, you know, mainstream media anyway, you email me. Okay, I don't care if I get 500, 1,000 emails, because I probably will. If you see that verdict coming and you do not see me live, you better message me. Okay, so this stream will lead you to that stream. I've set it up tentatively for, let me just check. I think I set it up for like 4 a.m. my time, 3 a.m. my time. Which is, wait, I think 8 p.m. Waukesha time, right? D-Banks, I wish I could explain it, but I'm not a lawyer, so I don't know how to explain that jury issue at all. Sorry about that. I was just like, I don't know what's happening there. All I know is that now it's verdict watch time. Okay, let me end the poll, then you guys can see the results in the chat. You should be able to see it there. So, whew, man, don't you think the state... That rebuttal was so brilliant. They really cleaned that mess up, right? And you see Jessy's got her cross like perfectly here today, just showing for the world, okay? She is ready to convince the jury of her innocence, which I don't know, man. I see it quite clearly what happened here. To me, I'm not like, there's maybe reasonable doubt. I don't know. Kuchler lied a lot, and the witnesses that she had on the stands lied too, in my opinion. That friend of Jessy's mom, what a liar. And the FBI handwriting analysis was obviously, a lot of it was inconclusive, because I don't know if the lady knows either that Jessy is a known fraudster. She's got many charges in the past. We looked at ones from 2010. Someone emailed me the other day to say I must look further back because she's got lots of fraud charges. Okay. So thank you so much for watching this with me. I really appreciate it. I don't think I could have made it. I couldn't have made it through that defense closing arguments without you. It was so frustrating. But I think that attorney Abbey Nickolie said everything that we were thinking. It was so good, right? I like how Celia Ryan says, chat way too fast. Well, there's not much we can do about it if there's 4,000 people here. You know what I mean? We can only slow it down so much, especially members. Remember, slow mode doesn't apply to you. So if you could just consider typing a little less frequently, it might help. It might help. But also, no, you can use your finger to just slow the chat down yourself on your device, okay? Yeah, Jerry says, G, get the Red Bulls ready. It's time for a power nap. You wake me if they come back within an hour, okay? Yeah, so I'm glad that attorney Abbey Nickolie addressed all of that, because I wrote down a whole bunch of things that Kuchler said. You know, the boatload of stuff and the powdered donut and people pulling her out of her chair and, oh man, smoking the cigarette, everything. All the things that she said about Lynn, and all the ways she attacked all the state's witnesses as well. I mean, and the friends. They're not good friends. They're giving birthday gifts 3 months later. Like, wow. A lot of low blows. A lot. So, and even that she looked older than her age. Why do you need to say, why are you saying that? My goodness. So glad and so proud of attorney Abbey Nickolie. Attorney Abbey Nickolie, if you ever watch this, we're so proud of you. The Grizzlies love attorney Abbey Nickolie, right? Okay. The jury doctor says 60-minute deliberation and 60-minute for lunch top. So the thing is, they started this at 12:21 p.m. in Waukesha, Wisconsin. They left the room. So now they're probably first going to have lunch. Now, if that is like, I don't know, how long is that? An hour, 90 minutes? Usually like 90 minutes, right? It was 12, 1. That takes us to like 2 Waukesha time. Then they got to deliberate and fill in all the paperwork and all that. So I don't know. I feel like it could be a little longer than we think, but we shall see. I've got the stream set up, okay? And if I need to shift it, obviously I'm going to just keep shifting it. So don't look at the time and go, yes, they're going to have the verdict in at that time. How the hell would I know? I don't have a crystal ball. I'm just setting up the stream so that we are ready. Make sure that you are subscribed, okay? Make sure your notifications are on, because you don't want to miss it when the verdict is in and read. I can't wait. Peter Pronzo, Harlem Raider says, another excellent trial presentation, G. We wait. No betting on verdicts. Lol. We are waiting. Yes. So that was just such a good rebuttal. I feel at peace again. I feel clean again after that, right? So thank you so much, everyone. Now what you're going to do is be teleported to the next stream. Are you ready? You should be teleported there. I'm going to make that one public, okay? This stream, after the outro, should teleport you there, but I will also put the link in the chat during this outro so that you can go there so long and click notify me. And the way, if you do that, you really should get the notification. It should even, usually, it depends on your phone settings, but make a sound, okay? That like, oh my word. And it might be, I don't know what time in the morning for me, but I'll be there. Okay, so I'll see you all again very soon. Let's teleport to the verdict stream, which, oh my word, I can't wait to be there with you guys. Can't wait. Okay, thank you, mods. Really appreciate it. Thank you to all my patrons, members, and everyone. If you haven't yet subscribed, do that, and we'll see you in the next one. Okay, bye.